For judgment, item 1, WPC 38 of the 2022.
There's the corrections. So the court has accepted the plea that he is to voluntarily retire with expiry of 3 months from the notice.
Right.
And therefore now they have to pass appropriate orders declaring his actual date of retirement and other consequential benefits. Period of absence, leave applications to be considered, appropriate order to be passed.
Right, I know, like,
Yes. So read petition has been allowed to that
Right.
extent. Yes. Yes, please.
8 is a lot, sir.
Yes.
Well, I am praying for listing of this matter, my lord, on 8th, my lord. Other similar matters were fixed on that day, my lord.
What is the matter?
The matter relates to my lord termination of contract agreement of the contractual employees of PNRD, my lord. Other similar matters were fixed on.
Can you like to be listed along with other similar matters?
I am giving the leading case number, my lord.
Then you mention it there. Mention it.
Yeah.
To be-
I am
Well-
sorry.
Malat, we are working from the year Malat 2005, my lord. In the meantime, another advertisement published, my lord. So I have challenged that advertisement, my lord.
Hmm.
And on 28/4, my lord. Matter may come day after tomorrow, my lord.
No, what matter? What
Matter
is-
is regarding Gabura, village head, appointment of Gaburas. Only we are 54 numbers in numbers and 360 posts are there.
This is read petition,
Read petition, motion matter
motion.
to be listed first time, my lord.
All right.
Wait, please, Lord. Listing of a petition, my lord. Connected repetitions already disposed of. It matter pertains to my appointment in CRP.
But next week, choose a date next week.
8,
No, 8 not possible. No further listing on 8.
12 then.
8, we have a list of 150.
12 mile,
cases. 12.
12 Friday. All right.
Please, Your Lordship. Yeah, my lord, one matter, it was fixed for hearing in the year 2016, but it is not listed till now. So I'm. praying
Why
for
it is
list-
not listed?
No, my lord, I do not know, my lord. I filed petition
Third
also.
week of May, third week of May. Third week of May,
Third week.
third week of May,
Okay, my lord. That
third week of May.
I understand.
Yes, next.
May I please, Lordship? With the consent of others, I beg to mention item note 12, Lordship. We are for the petitioner. Also, in this case, Learned Senior Counsel PK.
Item number?
12, Lordship.
Hmm.
Learned Senior Counsel PK Counsel, Wisami will lead us, Lordship. He has some personal difficulty today, Lordship. Lordship, can it be fixed on 16, Lordship?
You are for petitioner.
My lord, I am for
Six.
the respondent number
Buddha.
3, my lord. Both side, my lord, senior advocates are there. Petitioner, learned advocate PK Goswami. My side, my lord, VC Das. They are, my lord, convenient on 16, my lord.
No, for court, it is not convenient on 16.
If
Sometimes court's convenience also.
Well, but
matters.
urgency is also there, my lord, because my lord stay operating 16, 19,
Then
17.
we'll not adjourn it. Let's see. when the
Lordship,
matter
after
comes.
2 weeks, Lordship, any date after 2 weeks.
On the prayer of learned counsel for both the side, hearing of this matter stands adjourned for 2 weeks. List accordingly. Yes.
Another player, Lordship, in respect item number 15, Lordship.
Hmm.
I am for 2 and respondent 2 to 6, Lordship. I am from IOCL. Lordship, we have taken consent for the RSA. So it may fix after 2 weeks, Lordship.
Lordship, can it be fixed? Lordship, I am praying for the petitioner. Can
No,
it be
I'll not
fixed?
give any date.
After 2
On the
weeks.
Any adjournment in hearing list, there will be no fixed date
After 2 weeks.
after 2 weeks.
Oh,
On
bless
the
you.
request of learned counsel for the respond numbers 2 to 8 made with the consent of the other side. Hearing of this writ petition stands adjourned for 2 weeks. List accordingly.
Oh, bless you.
May I please, Your Lordship? My lord, I beg to mention 2 numbers of read petition, my lord. One is relating to the his pay fixation, another relating to the area salary, my lord. Any day next week, my lord.
No, in the last week of May. 4th week of May. Yes,
May-
4th week of May.
May please, Your Lordship. I have a player to list 2 matter. This is the review petition against the order of the writ petition, my lord. They have filed a contempt and the writ petitioner, my lord, got the lower mark than the last selected candidate. My, they have filed a contempt petition also. That is also fixed, my lord.
Hmm.
That may become on 4th of my lord, May.
No, 4th not possible. Next week, choose a date next week.
My lord,
9th.
9th,
Yes.
my lord, must
Lordship,
have
may I
that.
pray for the listing of a writ petition for motion, your lordship?
Hmm.
The urgency is that the petitioners are candidates in the combined competitive exam of the APSC.
Hmm.
And they had submitted applications for copies of their OMR sheets. The APSC is saying that till the exam entire process is not over, we cannot furnish copies. Difficulty is on the 5th, your lordship. The online portal for the mains will close, your lordship.
Hmm.
So we have filed a writ petition praying for copies of our OMR sheets, your lordship.
Now, why you want copies? of
Because
OMR?
there has been a correction in the answer key, your lordship, after the results were declared. We believe that our OMR sheets were not properly evaluated.
No, you want that before fifth, the court will direct and they'll give
No,
you the
no.
OMR sheet.
At least if we get the copies, your lordship, we'll be satisfied. And at least if nothing else, we will be able to submit a representation to the commission, your lordship.
That's fine. Why can't it be next week?
Because the portal will close on the 5th, your lordship. Even
We'll pass an order if you succeed.
very well, your lordship. Very well.
Milord,
Next week, your lordship. Obliged.
Milord, I have got a similar prayer, Milord. My case is something different, Milord. What happened in my case, Milord, they have published the answer key. After comparison of my answers vis-a-vis the answer key, Milord, the petitioners before your lordships, they qualified in GS2 paper as well as they have got more marks than the cutoff marks circulated by the APSC, Milord. My prayer is that, Milord, maybe taken up tomorrow, Milord. Maybe taken up tomorrow. There is urgency because on 5th they again close it.
It is a
My case-
motion.
Motion, Milord.
Yours is also motion.
Yes, it is also motion, Milord.
Okay,
Similar,
then both of you have your matters listed tomorrow.
my lord. Highly okay.
My lord, I like to mention for listing on writ petition, my lord,
Hmm.
maybe taken up on Thursday.
Listing for what?
For listing, your lordship.
Listing for listing.
So, sorry, my lord, for admission, my lord.
And what is the matter about?
My lord, relating to Anganwadi helper. and
Fourth week of May. Put it
My lord,
there.
there is some urgency, my lord.
Fourth week of May. Yes,
Lordship,
yes.
One compassionate appointment was had on 22nd of March, Lordship, fixing the date on 12/4. But it was not listed and the government is going to fill up all the vacancies on 5th, Lordship.
No, but you have an interim order.
There is no interim order, but Lordship was a hard
No, you can't expect the court to hear matters in time bound manner. That quickly hear and
That
pass
was
a
fixed on 12, but that was not listed. It is in the website, but in the court's order, it was not reflected. In my I have got message from the court also.
You give it to her. Check out if it is fixed, then ask why it is not listed.
Website it is, but in the court's order, it is not reflected.
Then you can't help. You give it to her, we'll see. If there is an order of the court, then yes.
In
Otherwise-
order, it is not reflected, but in the website, and I have got message for listing the matter on 12th April.
She will inquire about it.
Or Lord,
Yes, inquire.
May it please your lordship, I beg to mention hearing item 10.
Hmm.
As my senior counsel, Mr. S. Datto is out of station and we have taken consent of the
With
petitioner.
the consent of the learned counsel for the writ petitioner, a prayer for adjournment has been made in this case on behalf of the respondents on the ground that the arguing counsel is not available. Since the prayer is not opposed, same stands allowed. Let this matter be listed again after 3 weeks.
Must oblige.
Your lordship, I beg for listing a matter for admission. This matter was mentioned earlier and was held on 10th of March. The counsel from respondent number 3 side were to file the Wakalatnama after holy vacation. And accordingly, the matter was to be listed after a week. So far, the matter hasn't come up. So the matter may urgently be listed.
Tell the registrar this has happened. Go and meet him. There is a joint registrar of bench. You tell him that these are the problems, please sort it out. If he doesn't, then you come back.
May it be Lordship. I am praying for listing of a matter for motion tomorrow, Lordship. APSC selection was done for combined preliminary examination. Out of that, 4 questions was erroneously given and I made application but in claim format. But that was not considered and final result was published. And 5th is the last date for making application for mains exam. Therefore, matter may be heard tomorrow, Lordship, for some interim order.
May I please your lordship, I am on behalf of Anbar. Due to some difficulties, he is out of station. Item number 13 may be taken up some other day.
On the prayer of learned counsel for the petitioner, hearing of this matter stands adjourned for 4 weeks, list accordingly. Yes.
May it please your lordship. Lordship, I want to pray listing of an writ petition, lordship, family pension to the, I am the first wife, lordship. And he is for the petitioner second
Sorry,
wife.
lordship, I was out of station and the matter was listed, but I pray for listing the matter, lordship, jointly.
But 4th week of May, before that, it is not possible.
Lordship
Lordship,
is-
already they have initiated some proceeding. Only on last occasion, my learned friend was absent.
Then in another court, not this court, because I have already fixed matters.
Lordship, it's
Lordship,
related
it was-
compassionate family pension, lordship,
It
pension.
will come in court number
Now,
7.
what is that you want?
Lordship, for listing only early listing, lordship, they have.
Yes, 3rd
office-
week of May.
Lordship.
Yes, 3rd week.
Of
March.
Any list for withdrawal, I can see.
May I please, your lordship, my lord, in persons to the order of the honorable court, my lord, I was being promoted, but no retrospective effect given, my lord, but will take legal recourse of that matter. So contempt may be closed.
Mr. Jay Borvial and counsel for the petitioner submits that in terms of the order of this court, his client has been promoted, but the grievance insofar as a refusal to give retrospective effect to the said promotion is concerned would be, can be assailed in a separate writ petition. First up, Mr. Borvial therefore submits that by granting leave to the petitioner to avail appropriate legal remedy, this contempt case be closed. Mr. A. Das, learned counsel For respondent number 6, your lordship, is present on behalf of the respondent number 6. In view of the submission made by Mr. Borvial, this contempt case stands closed with liberty as follows.
Oblige, your lordship.
May it please your lordship.
Yes.
This matter, your lordship, on the earlier occasion, lordship has fixed it today. Matter relates to promotion with retrospective effect against the honorable court's order. The gist of the matter is that there was a earlier litigation. The challenge was made to his promotion, to the private respondent's promotion, which was set aside by this honorable court, holding it to be illegal. Now thereafter, after the order was passed, they have again promoted him. The part of promotion we are not against, but giving him the retrospective effect from the date when the earlier order was passed and that was set aside. And that is under challenge before this writ petition. So the issue is basically that whether they are entitled, he is entitled to get it retrospectively from the date when his earlier selection was set aside by this honorable court by a reasoned order. This is basically the effects of the case.
You are appearing for?
For Mr. D. Nath Lordship, he is appearing for Rubber Board of India Lordship for respondent numbers 2, 3, and 4. I'm praying for slight accommodation. Today he is not available. He is out of station Lordship. It will be taken up in the next week.
Yes, Mr. Manan.
He says that he is not available. Then your lordship, because the other person is also.
You either object to the prayer and I will record it and go ahead in hearing or agree to it. There is no third option.
First option.
Objection.
I'm going ahead with the hearing.
He is not agreeing, so you have to sort it out at the bar. Yes, I'll record it that prayer for adjournment, he has raised objection.
But next week it may be taken up Lordship. Next week.
If lordship fix a date next week, hearing date,
No,
then
no,
I have
there
no
is
problem.
no guarantee.
That is the
If these
problem, because
conditions
it will
are-
again not come up for a long time.
Because today he is out of station Lordship.
This is, lordship will see, this is not the first time. There were.
But
I think-
promotion retrospective effect, what is the earth-shattering urgency?
I am senior to him, your lordship. I'm still stuck. He's been given promotion. Even after this order passed, there is a stay order by this honorable court. Even after the stay order, the next promotion was also affected. We filed a contempt petition also.
Contempt is also there.
Yeah, that is why contempt is also.
The next week, any day Lordship. I'll inform him Lordship.
But did you ask whether it is convenient for the court next week? You did not care. Nowadays, nobody bothers. Judges' convenience, forget it. They are here like machines. We
Then
will
any
have
day,
our
Lordship.
difficulties, but the day we want, cases must be listed and they will have to hear, deliver judgments. Is
And
it?
even in
No,
in
lordship,
fact,
it
that
is
the
not
private respondent is retiring, your lordship.
That I am not aware of. I am not aware of the facts Lordship. I am just making a mention on his behalf.
Heard Mr. Y.S. Mannan, learned counsel for the writ petition, also heard Ms. M. Devi, learned counsel appearing to the respondent numbers 2, 3, and 4, who submits that the arguing counsel engaged in this matter. Mr. D. Nath is out of station and therefore this writ petition be posted for hearing on another day. First up, although Mr. Mannan has objected to the said prayer by expressing urgency in the matter on behalf of his client, yet in view of the ground on which the prayer is made, same stands allowed, registered to list this case for hearing again on 18th of May 2023 as a fixed item along with the connected cases. Yes.
Obliged to you.
Much obliged.
Item 4.
May I please, your lordship? Lordship, affidavit is prepare lordship and send for vetting lordship.
What is the matter about?
Matter relating my lord compulsory appointment. Compulsory appointment. The prayer of the petitioner was rejected on the ground of financial soundness. And that was respondent was asked to clarify that what amount is the financial soundness, and they have to clarify
By
that.
when will you file the affidavit?
Lordship, any sort that lordship.
Achha,
It's
Mr.
for
S.
getting
Learned
lordship.
Counsel for the petitioner is present. Mr. Your name, please?
DJ Boro.
Huh?
DJ Boro lordship.
Mr. DJ Boro, Learned Counsel has appeared for the APDCL authorities and submits that affidavit on behalf of the department is ready and has been sent for vetting. Mr. Boro assures this court that the affidavit will be positively brought on record within 2 weeks from today by serving advance copy upon the petitioner's counsel. On such ground, a prayer has been made for adjourning this matter for 3 weeks. Prayer allowed. However, it is made clear that if no affidavit is filed by the department within 2 weeks from today, the matter will be taken up for disposal at this stage of admission hearing. On the basis of materials available on record.
And the play of last week.
Accordingly.
Item 5.
May it please your lordship. Lordship, the writ petitioner was a UB constable lordship. He was dismissed from service on the allegation of a criminal proceeding was initiated against him. The under POCSO Act lordship. The criminal proceeding is yet to be tried by the learned trial court, and he was placed under department, after departmental proceeding, he was placed. First inquiry notice was served, he replied, and then lordship second inquiry show cause notice was served. And he again replied stating that there was no medical injury report in lordship in favor of the victim lordship. In spite of all those lordship, he was placed dismissed from the service. But he was not given any opportunity to cross-examine the witnesses of the lordship inquiry.
Where is the order?
Lordship. I have earlier filed one writ petition, lordship, and thereafter we are permitted to file appeal. Again, lordship, we filed appeal, and thereafter order was passed, lordship.
But that was denied by us in our affidavit of position that she was given opportunity to cross-examine. Thereafter, her the petitioner's signature was also obtained. If that is the dispute, most probably the record will be required in that case, as because we have disputed that fact.
You have disputed by filing affidavit.
Yes, by
Yes,
an affidavit in
the affidavit was
paragraph 10, lordship, at page, may I? At paragraph 10, page 66, affidavit filed by respondent number 1 to 5. May I read, lordship?
Yeah.
Statements made in paragraph 12 of the petition are not incorrect, vague, and lack material particulars, and a deponent deny the same, which are not borne out of record. Further, a deponent begs to state that out of 5 prosecution witnesses, the statements of 3 witnesses who were the primary one were recorded in presence of the delinquent, that is the petitioner, and he was given the opportunity to cross-examine the witnesses as per law. The signature of the delinquent was also taken on the copies.
You have not filed any rejoinder.
No reply has been filed.
You don't want to file.
Lordship, the entire, we have taken the grounds that lordship in the writ petition, the same facts is to be filed in my rejoinder again, lordship. As they
No,
have,
so then your writ petition will have to be dismissed today itself.
That's
Because
because we
you
have,
say they
yes.
have not given you chance. They say they have given you chance. We are not rebutting it. So what option is there for the court?
then your lordship will file a rejoinder,
And
lordship,
you are, as if you are putting a condition to the court.
lordship.
The rules of pleadings are very simple. You are making we are not accepting evidence here. We'll go by the record.
Lordship.
You make an allegation, they deny it. You remain
Lordship,
silent.
then your lordship may call for the records. In the meantime, I will file my rejoinder also, your lordship.
Let them deny it, lordship.
But anyway, order of dismissal, we'll have to hear it.
Yes.
But we'll post it for hearing then.
Lordship,
Yes.
lordship, in the admission stage, if possible, lordship can be disposed of.
No. All matters, how can it be done in the admission stage?
Lordship,
We can give you a fixed date of hearing.
lordship.
Take down. Heard Ms. R. Chaudhary, Learned Counsel for the petitioner, also heard Mr. H. Chairman, Learned Additional Senior Government Advocate Assam. In this writ petition, the order of dismissal from service dated. Is it 7/10/2022?
Yes, Lordship. Lordship dismissal order.
Yes,
Lordship, that is
7/10.
annexure 9, page
I am
42.
not asking the
Date,
annexure
date.
number. What is the date of the order?
Lordship, 4th July 2022.
4/7/2022. Has been inter alia put under challenge on the ground that the petitioner was not given opportunity to cross-examine the witnesses examined by the department. Full stop. The said assertion has however been denied by the state respondent numbers 1 to 5 by filing affidavit. Full stop. Ms. Chaudhary submits that she will be granted 4 weeks time to file rejoinder. Full stop. After hearing the submissions of learned counsel for the parties, this court is of the opinion that the matter would require full-length hearing and also perusal of the relevant records. Full stop. As such, admit the repetition. Since the parties are already represented, no further notice is required to be sent in this case. Register to list this case for final hearing as a fixed item on 15th of June 2023. In the meantime, the writ petitioner to file rejoinder, if so advised, the learned government advocate to produce the record on the next date of hearing.
Much obliged.
I'm deeply.
My lord, in this case, no live issue is there, my lord. The relief prayed for has already been granted by the bank. So, yes.
All right. Mr. S. Chakravarti, our counsel for the petitioner submits that the grievance of the petitioner has been redressed by the bank given the pendency of the writ petition and the outstanding dues have already been paid to him. Full stop. As such, nothing further survives for adjudication in this case. Full stop. Learned counsel for the bank has however not appeared today. Be that as it may, in view of the submission made by Mr. Chakravarti, these writ petitions can dispose of.
IA is also there. I can press my IA instead of it. Please, your lordship. My lord, for the respondent, we have also filed an interlocutory application for vacation of the stay order that I will press, but in the process, my lord may dispose of the entire case.
Mr. Tiwari, before we start,
My lord.
there was a time when matters contested used to be fixed for hearing.
Yes.
Everybody now wants it to be decided in admission. The reasons are understandable. When admission quota will overflow, people will want it to be decided in motion.
My lord,
And maybe at some stage before the matter is filed.
My lord.
This is how we are progressing.
My lord, there is another way of looking at it. If in cases like transfers or construction of mega structures, if interim orders are given in a jiffy, then obviously, my lord, there would be a pressure to seek disposal of the cases in the admission stage. It's a case of transfer. My lord, hearing of a transfer case means, my lord understands what it means. So therein lies the problem.
Yes. What is the case?
Now, my lord, the petitioner is manager civil in NHPC, and he has assailed, my lord, the legality of annexure 8 transfer order, page 53 of the writ petition. Page 53, my lord, the name of the petitioner is at serial number 3. My lord will find here the present location, Subansiri Lower Hydroelectric Project. From there, he was transferred to Baira Siul Power Station. Now, my lord, Baira Siul Power Station happens to be in Himachal Pradesh. So far as transfer policy is concerned, my lord, of NHPC, in the transfer policy, there are total 5 clusters that I will show. There are total 5 clusters which are subdivided into 3 categories of hard posting, difficult posting, and soft posting. So far as the present posting is concerned, Subhansiri to Baira Seoul, it is a transfer from one soft posting to another soft posting. Both the places are in the soft posting category. My lord, for clarity, may I present the transfer policy itself? The relevant page is page 46 of the writ petition. Para 3.3 of the writ petition, page 46. It is part of the transfer policy.
Yes.
Transfer policy begins from page 44, annexure 5 is the transfer policy. A, hard posting, clusters are given. Now, my lord, in this cluster 1 is in hard posting. My lord will just notice the third place. There is a purpose behind it. Tawang Basin Project. This is the place where in his service career, once the petitioner was transferred. And my lord, my submission is going to be, in which I will demonstrate with the help of the self-made chart of the petitioner, that throughout his service career, he was transferred to only once to a hard place. This is Tawang Basin Project. Difficult posting, he was never transferred to difficult posting in his 19 years of service career. Third is soft posting. In soft posting, my lord, there are 3 clusters, cluster 3, cluster 4, and cluster 5. Makes no difference. They all fall into the category of soft posting. Now, in soft posting category, my lord, will notice the first is Subansiri Lower HE project, where he was presently working. Then, my lord will also find Tista 5, Tista 4, Tista Lower Dam, Tista 6, etc. It's all soft posting because he was posted there once. Siliguri, also soft posting, he was posted there once. Then, my lord, Baira Seoul, my lord will find in third line, where presently he has been posted. In fourth line, my lord will find Parvati 2. Parvati 2 also he was posted once. So practically, my lord, in his 19 years of service career, only once he was in Tawang Basin Project, a hard posting. Rest of his career, throughout, he was in soft posting. This is point to be noted. Now, my lord, I will take your lordship to the self-made chart of the petitioner. It is in paragraph 5, page 6 of the writ petition. Chart is correct. There is no difficulty about it. I am relying on this chart. It begins from page 6, para 5. Now, my lord, from his side, the moment we look at the chart, we ask ourselves, oh, it's frequent transfer. So many places. But in reality, lordship will notice the first location, Parvati 2, soft posting. There he was from 19/1/2004 to 36/2008. 4 years he was there. Second, again, my lord, Parvati 2 only. One office to another office within the same place. So till 2009, my lord, he remained in Parvati 2. It is practically one posting, I'll call it. Then comes the Tawang, the only hard posting in his career. He was in Tawang from 2009 to 2011. It was unfortunate, my lord, transfer for him because there he was met with an accident. It is true, it was a major accident, and my lord, it is keeping that in mind that thereafter he was posted in Kolkata, regional office Kolkata, from 2011 to 2014. It is not shown in the chart, but it is understood to be a very, very comfortable posting naturally. Because of his major accident, he was put to Kolkata. So for till 2014, he was Calcutta. Then, my lord, Tista, 2014 to 2016. Practically, it is shown as 3 different posting. In Tista, he continued till 2018, soft posting. Because after Kolkata, Tista, again in Bengal. From Tista, my lord, in fact, in Tista, he continued till 2020. So 2014 to 2020, for 6 long years, he was in Tista only. Followed by Siliguri. My lord, we all know very well, Tista and Siliguri, what is the difference? So Siliguri, thereafter he came to Subansiri. Now Subansiri, my lord, it is true, December 2021 he was posted, and within a short period he was sent to Baira Seoul by the impugned order of transfer. Now, my lord, normally in a soft station, the tenure is 4 years. Then why they have posted him before 4 years? The reason given is in our affidavit, and my lord will find in the affidavit in paragraph 9 of the stay vacation application, we have given the reason. I read that, para 9 of the stay vacation application. Sorry, it's a mistake. Para 15, not para 9. Pages 9, paragraph is 15 of the stay vacation application. Page 9, para 15. This I read, one paragraph. That in the case of the petitioner, his transfer was felt necessary to meet exigencies of work at Baira Siul Power Station, which has shortage of executives of civil discipline. Whereas Subansiri Lower Hydroelectric Project has adequate number of executives of civil discipline. In Baira Siul Power Station, against the sanctioned strength of 13 executives of civil discipline, there are only 11 executives of civil discipline. Whereas in Subansiri Lower Hydroelectric Project, against the sanctioned strength of 47 executives of civil discipline, there is a posted strength of 54 executives of civil discipline. To meet the shortfall in the executives of civil discipline at Baira Siul Power Station, the management deemed it fit to transfer the petitioner, who is an executive of civil discipline of E5 category. Hence, the impugn order of petitioner's transfer was issued in administrative exigencies in public interest. Now, my lord, to counter this, now the argument which is being advanced is, well, why I only? There are so many in the Subansiri. Somebody else could have been posted in my place. You know, to that, the answer is very simple. The management deemed it fit that petitioner would be the most appropriate person to send to that very particular place. Somebody has to go. One can't advance an argument that no, those who have served for a longer period in Subansiri, they have to go first. There is nothing of the kind. For a particular place, particular man was found more suitable. So the decision was taken. Now, my lord, one by one, my lord, I will take the arguments. So, my lord, firstly, the first argument was of frequent transfer. In connection with the frequent transfer, there are 5 reasons I will give. Number 1, in practical terms, from 2004 to 2022, 18 years, plus the present then 19 years, there have been only 6 transfers, practical terms. 7 transfers if the present transfer is taken into consideration in 19 years. So it is not a case of frequent transfer. 2, throughout his service career of 19 years, only 1 transfer to Hard Station, cluster 1. 3, the impugned order of transfer from Subansiri to Baira Siul is from one soft station to another soft station. 4, from 2014 to 2020, for 6 long years, petitioner was in the Teesta power project because they are alleging malafide. So I'm saying, look, we have been very considerate with you. No question of malafide. Your service career shows it. And my lord, thereafter, my lord will also notice, petitioner has spent more than 10 years in cluster 3. 10 years in cluster 3. Now, my lord, lordship may notice a few paras of the transfer policy. The first is page 45 of the writ petition. Page 45 of the writ petition. Para 3.2 of the transfer policy. I read below para 3.2. Page 45 of the writ. Para 3.2, my lord will find. Policy says.
So what is the ground of challenge? Frequent transfer.
Frequent, number 2, malafide. Number 2, malafide. Number 3, amongst 9 officers having same designation in the Subansiri Hydro project, the petitioner has served for the shortest period in the present place. Among the officers of same designation, that is manager civil, there are 9 officers including the petitioner in Subansiri Lower Hydroelectric project. According to petitioner, he has served the shortest period in Subansiri. There are 8 others with manager civil designation. Any of them could have been transferred. This is what he says. So now, my lord, I'm showing the policy. And then, my lord, another ground is that the transfer of the petitioner was not strictly in terms of the transfer policy because the committee recommending his transfer was not properly constituted. I will deal with that also. First, paragraph 3.2 of the policy, criticality of manpower for both donor and the recipient department, project office employees will be considered for transfer after they have spent a minimum of 2 years at hard location, 3 years at difficult location, and 4 years in a soft station. However, employees with long stay within one region and or one cluster for more than 10 years will necessarily be transferred out from region and cluster unless otherwise decided by CMD in the interest of work. My lord, there is no denying the fact that he has spent more than 10 years in cluster 3, soft station all throughout. Then, my lord, the next relevant para, 3.4 of the policy. 3.4 may also kindly be seen. Transfer shall be made from hard stroke difficult to soft posting or vice versa on the basis of requirement and completion of the tenure of an employee at a particular location. As far as possible, for posting it in at the immediate previous station, cooling off period of complete tenure of present location or 3 years, whichever is earlier, is necessary, which may be relaxed by CMD in view of organizational requirement. So transfer shall be made from hard difficult to soft or vice versa. This is what the policy says. That is not the case with the petitioner. From one soft station to another soft station. And he has been in soft station for most of the time in his service career. So, my lord, those portions of policy which have been flouted for his convenience, he is not bothered. He is looking into other aspect. Then the next is 3.5. This part also of the policy has been flouted for his comfort. 3.5, in case due to some reason or other, transfer of an employee is not possible from hard stroke difficult to soft or vice versa, then he will be considered for transfer out from one cluster to the other and not within the same cluster. Again, same cluster, one soft station to another. So it is not that, my lord, if we wanted to disturb him, we could have disturbed him in a bigger way. Nothing of the kind was done. Now, my lord, we come to the power of the CMD. In his case, my lord, after the recommendation by the committee indeed recommended him. The committee consisted of director personnel, director project, and executive director HR. And it was approved by the chief managing director of NHPC. So far as chief managing director is concerned, my lord, he has exclusive powers under the policy. His powers, my lord, will find para 3.12, Roman 4. 3.12, Roman 4 of the policy. In situations involving administrative exigencies, where consultation with concerned functional director is not possible, CMD may order such transfer in the interest of work. Then again, my lord, para 3.15. The management, however,
CMD is chief managing director or chairman cum managing director?
Oh, sorry, chairman cum managing director. Chairman, I'm sorry, my lord, I stand corrected. 3.15. The management, however, reserves the right to make transfers on administrative grounds. So, residuary powers are always there. Here, my lord, transfer was approved by the chief managing director. And so, my lord, practically there is no ground. I cite only one judgment. Govardhan Lal, my lord, is so familiar with it. Transfer policy is also not enforceable. In any case, they are mere guidelines. Paragraph 7 and paragraph 8 of the Govardhan Lal. I press, my lord, may I read the paragraph? Para 7. It is too late in the day for any government servant to contend that once appointed or posted in a particular place or position, he should continue in such place or position as long as he desires. Transfer of an employee is only an incident inherent in the terms of appointment, but also implicit as an essential condition of service in the absence of any specific indication to the contrary. In the law governing or conditions of service, unless the order of transfer is shown to be an outcome of a mala fide exercise of power or violative of any statutory provision or passed by an authority not competent to do so, an order of transfer cannot likely be interfered with as a matter of course or routine for any or every type of grievance sought to be made. Even administrative guidelines for regulating transfers or containing transfer policies at best may afford an opportunity to the officer or servant concerned to approach their higher authorities for redress, but cannot have the consequence of depriving or denying the competent authority to transfer a particular officer stroke servant to any place in public interest, and as is found necessitated by exigencies of service, as long as the official status is not affected adversely and there is no infraction of any career prospects such as seniority, scale of pay, and secured emoluments. This court has often reiterated that the order of transfer made even in transgression of administrative guidelines cannot be interfered with, as they do not confer any legally enforceable right unless as noted supra shown to be vitiated by mala-fide or is made in violation of any statutory provision. So, my lord, my submission is, number one, there is no violation of a statutory provision. Number two, apparently, my lord, no mala-fide has been shown, no mala-fide has been attributed to any officer. Number three, career prospects have not been interfered with. Number five, it is not their case that it has been passed by an authority not competent to do so. So practically, my lord, they don't have a case. My lord, there is the representation also
Which are
pending.
the para numbers in this judgment?
Paragraph 7, my lord, and also paragraph 8 of the Govardhan Lal, state of UP, may kindly. 7 and 8. So, my lord, that is all. There is nothing in this case. And, my lord, in fact, representation is pending, but on the earlier occasion when the matter came up before my lords, I suggested that let the writ petition be disposed of, directing the authorities to dispose of the representation with the speaking order within a week time. But then this was not acceptable to them. So, my lord, my submission would be, if they ask for representation disposal, that stage is over, because they chose not to accept the proposal. Now, my lord, we have disclosed our stand. It is there in the affidavit, the reason we have given, and we feel that it was in the administrative exigency that the competent authority deemed it fit to transfer the petitioner from Subansiri to Bairasiri. And it's a good place. In fact, facilities are far better than Subansiri.
Where is it? Where is this place?
Himachal Pradesh. All facilities are there, including the hospital, Kendriya Vidyalaya, everything. Nothing of the kind. So, oblige me not, that's all. If something special comes up, I will give a reply.
May I please? The writ petition is basically, I am not saying that we have the absolute right of staying in the same place. Our case is different. The General Council are agreeing the matter in the different line. My question was a very limited one. My question was that I am transferring this plot only on 1.5-3 months. And there is a specific rule policy of the NSVC were accepted by the department as a whole, and my senior consultants also that they are following that policy and they are going on that policy. That policy indicated that how to transfer should be made. And that policy is made only for the transparency of the policy that is very indicated in the policy itself. And that policy said that if exigency, it is.
Mr. Borua, you see, you know, the law on transfer is very well settled.
Yes.
Even if the order is in violation of policy, the court will not interfere. But it is not in violation of the
Yes.
policy, that will address. There are only 2 or 3 grounds on which a court can interfere with a transfer.
Yes.
One is violation of statutory provision. Number 2, if it is actuated by mala-fide.
Yes.
And number 3, if it results into alteration of conditions of service of the petition.
Yes.
Which of the 3?
Yes, I am on that parameter.
Which one?
Yes, not even. First, that is a rule. It is
What is that?
that is a policy. The policy means because in fact there is no specific statutory rule of the NSVC. The NSVC is guided by their own provisions, rules. They have a transfer policy, they have a promotional policy, and that is resolved in the board of directors. Then after approval, that is implicated. It is not a government organization that there is from statutory rules. And moreover, here is they said that what they're trying to say. They're trying to say that we are giving in the soft posted soft post, therefore we are not. What on record I have given this specific reply on their I have showing in the reply that is not fact. I am at a point of time in my career, I have never challenged any transfer order, even more than 40% of my tenure. When I am working, I am in hard and difficult posting. I am working at difficult posting, more than 40%, 7.5 hours. Details I give in my reply. And it is not that I am for soft posting. This is not my case.
What is your difficulty in going to Himachal?
My given is, if Lordship will find record that administrative, they say now said that's an administrative exigency.
Forget that. What is the problem in going to Himachal from Lower Subansari? What is the difficulty of your client?
No, difficulty is Lordship. I am not on the.
No, that's exactly on what we will pass the order.
I am
No,
just.
we are not getting into
I
academic.
am just come 1 and 3 months. My student, my son is thus they admitted and they are in class 9 and all this thing. And they are and my whole there were one there were
See,
at least.
the new academic session is now beginning.
Yeah,
All right.
yeah.
It is up to you.
And
If
the
you-
way
if you
they
do not press this petition, we can give you some time, 15 days, 20 days to join. Otherwise, if a judgment comes, then if it goes against you, you may not get a single day's time to.
My submission, I'm very, I know the limitation, my limitation, I know what is my limitation, that is I am not. But the way these things are that if they say they are the exigency, I have nothing to say. I have to go. And with
Mr.
administrative
Barua, I am asking you one question. If I write a judgment, then I will go into various aspects. Do you want that? Think about it.
No.
Get instruction from your, if I write a judgment, then I will go into various aspects.
And also my another thing there, I have already all given it. That is, the higher authorities should have considered the transfer this part. I have already submitted an representation on before the. And that time, that period of time, that yet not be decided, but they call on that. And at least that should be disclosed. Then Lordship, if Lordship will have no difficulty, Lordship that it will even come in after days tomorrow, then I will take instruction. I will place whether and the representation is also already been there. And if there with some difficulties on accommodate for some period of time or other period of time, then otherwise I am that I am very first I am saying that my transfer is to state is very limited ground. And they said they are the now I am they said the committee. There's some the thing is placing the which is not because of the fact that CM they say they have authority there. Nothing has been taken. Administrative exigency, they can transfer even there is no go by that provision. But in the order itself says it is not for administrative exigency. For if the administrative CMD have to be passed the order, required to be passed. And the IA file, for timing I am taken that is the stand of the NSPC. The IS file person, he is not only he is with authority file, but all are find it IA is very interesting. All are giving knowledge. The affidavit file on basis of knowledge. If the record shows there is as per policy, the committee have recommended my being my suitable for the posting of that version for transfer, that much, if the record shows there's a exigency, I have nothing to say. I will go. If the record shows, I am not want to, I will not giving any submission at that time. There is the record and shows that number five, as per policy, the committee have decided that conscious decision has been taken, and I am a suitable person, exigency, I am transferred. I have nothing to say. Just because I also find that is a basis on knowledge. I don't.
Without question of production of record would have arisen had prima facie case of malafide been made out. Where is the question of production of records?
Production record, where the question I have raised, there is a specific question I have raised, that I am not, the committee has been not consulted, the person competent has been, as per policy, not issued the transfer order. Then why is their side to give the record before?
Question raised and question answered by way of an affidavit. And in any case, it's a transfer policy.
All right, that's all.
That's why, but that only the record, can see the record, if the agency, if they did ground, we have taken, it will taken, consider.
The read petition and the IAC number 1026 of 2023, both this, sir. Take down hard Mr. P.P. Borua, learned counsel, assisted by Mr. D. Goswami, learned counsel appearing for the read petitioner. Also heard Mr. P.K. Tiwari, learned senior counsel, appearing for the assisted by Mr. A.R. Gogol, learned counsel appearing for the respondent numbers 2 to 5 in the read petition and the applicants in IA record civil number 1026 of 2023. Full stop. This read petition is being taken up for disposal at the stage of admission hearing with the consent of learned counsel for both the sides. Full stop. The petitioner hearing is serving as a
Manager civil.
Huh?
Manager civil.
Serving is working as manager civil and posted at the Gerukamuk NHPC colony. No, Gerukamuk NHPC project.
Lower Subansiri hydroelectric project.
Posted at the Lower Subansiri hydroelectric project at Gerukamuk in the district of Dhemaji in Assam. Post of assailing the transfer order dated 10/3/2023, by means of which the petitioner was transferred from the Lower Subansiri hydroelectric project bracket HEP bracket close and posted at Baira BAIRA then SIULPS. You'll find it in page 53 of the read petition. The instant read petition has been filed inter alia contending that this is a case of frequent transfer and the transfer order has been issued with the malafide intent of causing harassment to the petitioner. Full stop. According to the petitioner's counsel, his client had been posted at the Lower Subansiri HEP only 13 months back, and therefore, before completion of normal tenure of posting, the petitioner is being sought to be shifted again. And that too, without the approval of the chairman cum managing director bracket CMD of the respondent number 2. Full stop. Taking note of the arguments made by learned counsel for the petitioner, this court had passed order dated 17/3/2023, suspending the operation of the transfer order dated 10/3/2023, qua the petitioner. Full stop. The connected interlocutory application being IA bracket civil bracket close number 1026 of 2023 has been filed by the respondent numbers 2 to 5, seeking vacation oblique modification of the order dated 17/3/2023 passed by this court. Full stop. Mr. Borwa, learned counsel for the petitioner, has argued that there are 9 other officers of the same grade posted at Subansiri Lower HEP, but the petitioner has been picked up for premature transfer without there being any justifiable ground for doing so. Full stop. According to Mr. Borwa, this is not a transfer order issued in exigencies of public service, and the said fact would be established once the departmental records are produced before this court. Full stop. Countering the arguments made by the petitioner's counsel, Mr. Tiwari, that is senior counsel for the respondent numbers 2 to 5, has argued that the transfer order is purely in the exigencies of service and has been issued in strict compliance with the transfer policy of the respondent number 2. Full stop. By taking the court through the transfer policy, Mr. Tiwari has argued that there are 3 types of postings under the respondent number 2, namely, number 1, hard posting, number 2, difficult postings, and number 3, soft postings. Full stop. The present transfer order envisages shifting of the petitioner from one soft posting, namely Subansiri Lower HEP, to another soft posting, namely Bayara Siul. Full stop. Mr. Tiwari further submits that during the entire service career of the petitioner, commencing from 19/1/2004, he has been given only one hard posting till today at Tawang Basin during the period from 1/7/2009 to 9/11/2011, and the rest of the tenure of the petitioner has all along been in soft postings. First of, moreover, submits Mr. Tiwari. Clause 3.2 of the transfer policy mandates that no employee be allowed to stay within one region or within one cluster for more than 10 years. First, despite the same, taking note of personal difficulties faced by the petitioner, he has been allowed to remain in one cluster.
Cluster 3.
Remain in cluster 3, Roman 3, capital Roman 3, bracket soft posting for a continuous period of 10 years.
More than 10 years.
More than 10 years. And even now, he has been posted in an area which comes under cluster 3 posted. By referring to the statements made in the application filed in IAC number 1026/2023, Mr. Tiwari has argued that there are genuine reasons for which the petitioner has been transferred and sees no case of mala fide and oblique or violation of any statutory provision or condition of service of the petitioner is envisaged in the present transfer. The writ petition is liable to be dismissed with cost. In support of his above argument, Mr. Tiwari has placed reliance on a decision of the Supreme Court rendered in the case of State of UP and others versus Govardhan Lal, reported in 2004, bracket close 11 SSC 402. Full stop. I have considered the submissions made by learned counsel for both the sides and have also gone through the materials available on record. Full stop. By means of his pleadings in the writ petition, more particularly the table in para 5 of the writ petition, an attempt has been made to project that the petitioner has been subjected to frequent transfer. Full stop. However, on a closer scrutiny of the table given in para 5 of the petition, I find that the petitioner has been transferred only 6 times. In his petitioner has been effectively transferred only on 6 occasions in his 19 years of service career, with as the other transfers are from one office to another within the same location, and therefore would not come within the meaning of frequent transfer. Full stop. 6 transfers in a span of 19 years by any reasonable reckoning, in the opinion of this court, cannot amount to frequent transfer. Full stop. Insofar as the transfer policy of the NHPC is concerned, here also I find that there is a clear policy not to allow any employee to continue in soft posting for a period or in the same cluster for a period of more than 10 years. But in the present case, the petitioner has been posted within the same cluster, that is cluster 3, even though he has spent more than 10 years in a soft posting under the same cluster. I also find from the clauses 3.4 and 3.5 of the transfer policy that the residual power vests with the CMD of the organization to take a decision as to the question of transfer of any employee from hard, public, difficult to soft posting and vice versa. Full stop. It appears that the benefit of the power conferred under clause 3.5 of the transfer policy has been extended to the petitioner in this case by allowing him to continue in a soft posting beyond the period of 10 years. Full stop. Full stop. Moreover, full stop. The reason as to why the petitioner has been transferred from lower subaltern HEP to whatever that place is, Bias, whatever, has been spelled out in paragraph 15 of the application filed by the respondents 2 to 5 in ISC number 1026 of 2023, which is quoted, which is reproduced herein below for ready reference. Full stop. We have to just quote it in from the IA 15. Full stop. In the counter affidavit filed by the writ petitioner opposite party, the only response to the said pleading is that there were other officers numbering about 10 in total who could have been considered for shifting from the present post, but the authorities have picked up the writ petitioner with a malafide intent. Full stop. The learned counsel for the petitioner could, however, not substantiate his plea that the petitioner was picked up with a malafide intent. Full stop. Moreover, merely because of the fact that there are other officers of the same rank serving in the same station who could have been chosen for transfer, that cannot by itself be a reason to interfere with the order of transfer issued by the authorities after assessing the exigencies of service. Full stop. Law is well settled that that transfer is an incident of service condition, and the scope of interference with such an order of transfer in a writ petition is very limited. Full stop. It is not open for a government servant or an employee of a corporation to sit in appeal over an order of transfer and decide as to whether the order is correct or not, merely because he or she desires to continue in a particular place which is convenient to him, public her. The aforesaid aspect of the law has been aptly discussed by the Honorable Supreme Court in the case of Govindan Lal bracket Supra in para 7, which is reproduced here in below. Full stop. As noted above, the petitioner has failed to point out violation of any statutory provision, nor has the plea of mala fide been established based on materials on record. Full stop. The petitioner's counsel has also fairly submitted that the transfer order does not envisage any violation in the condition of service of the petitioner. Full stop. If that be so, the only ground on which the order could have been interfered by this court was on making out of a prima facie case of the order having been issued with a mala fide intent. Full stop. However, no such case has been made out. In view of the above, this court is of the opinion that there is no good ground to interfere with the transfer order dated so and so. Full stop. This writ petition is therefore held to be devoid of any merit, and the same is accordingly dismissed. Interim order dated so and so stands modified. In view of the observations made herein above, the IA number so and so stands disposed of. In the last para, you said the violation of statutory provision or condition of service, mala fide is not required. Then you write, under the circumstances, the only ground is mala fide, but no case is made of. Yes.
Please, Lordship, only at least 1 month, maybe they allow me to
That offer I gave you, you didn't take it.
that
Nothing. Let's maintain the sanctity of court proceeding. You already got 2 months of bonus.
Yes.
All right, all right.
May please your lordship. My lord, the interlocutory application, my lord, is for vacating the interim order passed by this honorable court. The last occasion, my lord had directed another writ petition also to be listed along with the.
Just a minute, just
My
a
lord.
minute. The ground of the statutory provision, or when the condition of service such under the circumstances, only ground, only other ground on if a case of mala fide exercise of power is there. However, the petitioner has not been point out or make out a case. Yes, yes, yes.
My lord, the order that is, my lord, sought to be vacated, your lordship will find in the IA page number 19, the relevant part at page number 21. Your lordship sees the penultimate paragraph of.
You are referring to IA or WPC?
My lord, the interim ordered, my lord, that was passed, I'm just referring to that for a while. That is in my interlocutory.
Which
application.
petition are you referring to?
IA, my lord, IA 544. At page number 19, the order, Indian order starts and relevant part at page 21. Now, my lord, the penultimate paragraph your lordship sees in the circumstances, in the interim, it is provided that the final seniority list dated 13/9/2022 shall not be acted upon for giving any further promotion until further orders, list after 6 weeks. My lord, the interlocutory application has been filed for modification of this order, my lord. And my mere ground, my lord, for my lord, modification of this order, my lord, stands on the footing that there was no promotion initiated.
No, no, just a minute, just a minute.
My lord.
Give me the record of the WPC. Acha, now, because of the stay order, your client is holding that post.
No, no. No one has been.
We'll ask them to make a officiating promotion, which will be subject to outcome of the litigation.
My lord.
Because you can't say that if I'm not promoted, don't allow him that.
Yes.
You can't say.
Only thing
That
is.
is the order will pass. You
Lordship.
can argue.
Lordship is correct. Only thing is, Lordship, already as per office memorandum issued by the authority, Worksas employees has been reverted to the original cadre. There is a circular from the government of Assam that all the Worksas employees which has been taken back to the general cadre by the authority illegally without taking concurrence from the authority were reverted back. Against that order, writ petition has been filed before this honorable court. Writ petition has been dismissed. Thereafter, writ appeal has been filed, writ appeal also dismissed. Now, Lordship, he is also works as employee. He has been encadred to LDA within the limited period by taking him the interview, and he was encadred to LDA cadre. This is not a recruitment process. So he has been encadred to LDA. Thereafter, he has been promoted to senior UDA STEM. So his initial appointment is illegal, and he has 6 years of service, and he will be and he is
His initial order of appointment was
Worksas.
dated
1990
no, LDA.
LDA 91
94, my lord.
94.
What is the order date?
7/3/1994, page number 36 of the writ petition.
That order is under challenge here.
That is under challenge.
So order of 94 challenged in 2022.
Lordship, because I have been affected when provisional graduation has been affected. And that is why I have challenged, Lordship. And the Honorable Supreme Court has said in a similar point of view that when a person has been appointed illegally, when a person has been affected, he can challenge this promotion order. There is no question of delay.
No, now tell us one thing. There is no question of the respondent number 5 being reverted because he was absorbed as a LDA
LDA,
by that order of 7/3/1994.
Lordship.
The question is whether that absorption could have taken place or not.
Lordship, already Lordship kindly see, the Worksas employee which has been encadred to the LDA
No,
and
Mr.
UDA.
Goswami, I'll request you to please first respond to the court's query. Then you come up with your story, but not intertwine.
Lordship.
I am asking you one question. If you are to succeed in the writ petition, the order that you would require is setting aside 7/3/1994, correct? That is what you would require. If this order is set aside, then the absorption of the respondent number 5 as LDA, this is a legal issue. We are not concerned with who
Lordship.
gets benefit, who
Lordship is
doesn't.
correct.
That is none of our business. That would mean that his absorption is illegal. In other words, he ought to have been reverted as a Khalasi. So if that order is passed today, he will have to be reverted as Khalasi. You expect the court to pass that order after a span of how much? Nearly 30 years?
No. Only thing is, Lordship, kindly see. Lordship, kindly see page 78. 78. This order has been in 2017. The authority has issued a notification
stating that in view of the above, Chief Engineer of Water Department is hereby directed to take necessary steps to revert back all such employees who are holding the personnel post and were illegally promoted or brought to the regular cadre to their original regulated by the post of personnel post immediately and after submit proposal to the ex post ex facto retention of the regular retention proposal of such employees. Further, since all these employees are either grade 3 or grade 4, if decided not to recover the amount they have already drawn till date, in such case, employees who have already retired from government service, their personnel will be refixed at the rate on the pay as he should be drawn on the date of his retirement from the personnel post. This has been issued on 28th day of August 2017. Thereafter, Lordship, this order has been challenged before this honorable court. At
No, was the petitioner, respond number 5 also part of this order?
Lordship,
How
some
does
of the
it-
person has been, Lordship, I-
Some, no, we're concerned about respond number 5. Was he
till
also
date,
reverted?
till date, no action has been taken by the
No action has been taken. So then, are you seeking a direction on the department to take action against him?
No, I have already filed representation of the authorities that similarly situated person in the water research department itself reverted back from LDA to the works as employee. Page 90. Same person as per the notification of 17 reverted from LDA to in 23, 2023 reverted back to the post of works as employee. But his case has been, he is an influential person. He is a, I could not disclose everything. He is a politically influential person. That is why he has not been reverted back. Already all the person in works as employee who has been promoted to LDA as per notification of 17 has been reverted back. So that order has been challenged before this court. That was dismissed. Retapil filed, retapil dismissed, but he was taken in the service till date. So if his appointment is irregular, he will above me. I'm a regularly encountered LDA post and I have been in its second position now. And he has 6 years of service. Till disposal of the authority by representation that why he was kept in the works as employee has been promoted to the UDS 10, LDS 10, UDS 10 without doing any action as per notification issued by the government. In case of other employees, they have reverted back. They have approached this court, that is dismissed. Appeal file, appeal dismissed, but he was taken in service. And now, because only the senior most person will be promoted to the post of Lordship,
Which is the order passed in by the writ court?
Lordship will find at page 79. Page 83 is the Lordship, the relevant portion. Page 83. Para 6. In the said writ petition, it was held that personnel post would mean ex-cadre post in service jurisprudence. Promotion is necessarily made from the feeder cadre to the higher cadre in the service, since the respective cadre from the part of service. Therefore, unless one is encountered to the feeder post, he cannot claim promotion to the higher cadre. Accordingly, as the petitioner therein were holding ex-cadre post, they are not encountered. Therefore, they would hold to be entitled to the next higher cadre. And ultimately, Lordship, this court has decided that writ appeal has been preferred.
No.
And that also dismissed.
Just a minute, I'm not understanding. You are saying there was a decision to revert all the LDS to the post of Khalasi in the Water Resources Department. Because those posts were personal, they were appointed against posts which were personal to them, post of Khalasi. And therefore, there was no question of absorbing them into the cadre, right? But the government decided that there will not be any recovery of salary, etc., drawn by them. Where is that notification?
Notification will also find at page 78 is the relevant portion. It start from page 76, relevant portion, page 78. I have also typed out also page 77, the relevant portion, because it is not legible.
So this notification of 28 August 2017 was challenged.
Challenge, Lordship.
And by which, where is the order by means of which it was decided?
Page 81, Lordship.
No, but where is mention of notification dated 24th August in that?
Lordship.
28th
Page
August.
7, Lordship. Page 17. Page 83, Lordship. Para 7. Writ appeal also appeal, Lordship. Single bench order.
No, I'm asking, Mr. Chakraborty, where is the order of the learned single judge?
My lord,
Which had rejected the challenge made to the notification dated 28th August 2017.
My lord, my senior colleague is referring to page number, from page number 79 to 85
Yes.
and paragraph number 7 is.
Learned single judge is referred to that order,
My lord,
Lordship.
which I am also asking for.
Lordship.
You are again and again saying.
I am aware, Lordship, that
Where is that order?
Lordship, that has not been annexed, Lordship.
That order will be required.
Lordship, I'll produce that order.
Where is that order?
my lord, that I've, my lord, these are the documents of the writ petitioners.
Then we
Here,
can decide this matter. I have to see that order.
but my lord, here
I
my,
will see whether, what was the direction of the single judge, whether your client also comes within the purview of this notification.
my lord,
And if so, we'll ask the authorities to decide if he comes within the purview of this notification, take appropriate action as per the court order.
my lord,
Otherwise, they will go ahead with the promotion.
my lord, my humble prayer. at
Nothing
this-
beyond that is
My lord,
possible.
one
You make a
page,
prayer.
one page, my lord, if your lordship kindly
Yes, yes.
permisses, just to respond to this query. Page number, in the first, my lord, page number 64 onwards,
Hmm.
this is also
Page 64 of which
writ
petition?
petition number 6236, my lord.
Hmm.
Now, if your lordship.
Can you get that order now? Can you give the
Lordship.
case number? You can find out in this short recess we have. Yes, page
My
number.
my lord, page number.
Already
60
there is direction of this honorable court to take the judgment passed by this division bench and the single bench. There is the earlier order.
What is the date of the order?
As far as my knowledge, Lordship, that was directed on earlier occasion.
My lord, will take page number 65 for a while, just to respond to this query. my lord. Page number 65, if your lordship kindly sees paragraph number 3. Actually, this is, my lord, the speaking order that was passed, my lord, by the authority.
That is under challenge.
That is under challenge. Now, there is an explanation, my lord, in regard to respond number 5, there's an explanation at page number 65, paragraph number 3, my lord. If your lordship kindly peruses this particular paragraph. My lord, may I read this particular paragraph? The submission of the petitioner in his representation dated 17/2/2022 that the respondent number 4, that time it was respondent number 4, that is so and so, was initially appointed as ward charge Khalase on 18/12/1990 and later on his service was regularized against personal posts have been carefully examined. It is to be stated that the government has created 1042 numbers of posts for ward charge and 582 numbers of posts for muster roll workers for regularization of the workers as personal posts, while government letter number so and so dated 1/10/2005. But it is seen that the respondent number 4 was appointed as lower division assistant, renamed as junior assistant against sanctioned post during 1994, which is much earlier to the introduction of a personal post as above. Hence, the charges of the petitioner is found to be not tenable. This was the plea that was taken in the earlier writ petition number 3727 of 2022, my lord, against which, my lord, there was an order passed by this honorable court, which your lordship will find at page number 58. My lord will take page number 58 for a while, my lord. The relevant part your lordship will find at page number 59. This was the writ petition in which also this issue was taken up. And there was a direction from this honorable court. Your lordship will kindly see the my lord, last paragraph. Any promotion, my lord, the respondents, my lord, there was a direction by this honorable court to dispose of directing the authorities to, my lord, inquire into the matter and pass a speaking order, pursuant to which, my lord, this is the speaking order that has been passed. Now, in the speaking order, what has been referred to at paragraph number 3 that I have just, my lord, pointed out before your lordship is, this personal posts were created subsequently, but so far absorption of respondent number 5 to the feeder, that is LDA cadre is concerned. That was in the year 1994. Thereafter,
How was this absorption done?
my lord, this
What
absorption,
process was followed?
the process, my lord, was of selection. Now, the selection, my lord, if your lordship kindly takes up, there was an advertisement on 24/9/1993 at page number 37. Page number 37, my lord.
Page 38 is the lordship, the how is it
I'll come to that, my lord.
Page 38.
I'll come to that. First of all, the advertisement, my lord. I know the notice, the notification, the type copy is at page 37. Your lordship kindly sees. Application from the willing ward judge, essay trader Khalasi of 3rd division, who has got the required educational qualification, that is HSLC, and having knowledge in typewriting, are invited to fill up the post of LDA in this division. The applicants are to apply through proper channel following particulars so as to reach the undersigned within 15 days from the date of issue of this notification. Application received at towards will not a written test and type test will be conducted for selection of the candidates under due course. Now, to my lord, pursuant to this my lord notice, the respondent number 5 along with 4 other incumbents, they participated in the selection process. And eventually the respondent number 5 was provided with the appointment, the selection on 7/3/1994, which your lordship will find at page number 39. That your lordship will find at page number 39. That is on 7/3/1994. Now, this was the inception of my lord, the respondent number 5's cadre of LD. 1994. Personal posts were created in the year, my lord, 2005. My senior colleague is referring to abolition and reversion and all this. These are in respect of posts which were created in the year 2005 by the government. And then there was reversion in 2017.
What is the date of this order? Page 39?
7/3/1994. And my lord, then if I might just trouble your lordship with my IA once again, my lord, just for a while.
Yes, yes.
My lord, in my IA, your lordship kindly takes up page number 22. Now, page number 22 is my regularization in the post of LDA. And the date is, my lord, will see 7/8/2001. This is my absorption, regularization in the cadre of LDA. After being selected in the year 1994, I am regularized in 2001. And then my lord will kindly, my lord, take up page number 24. This is my lord, regularization to the post of UDA. That is in the year 2008, 20 to 2008 to be precise. And after serving my lord in the UDA cadre, there came a stage where, my lord,
Yes.
my lord, there came a stage where a provisional list was published. In that provisional list, I stood at number 1. My senior colleagues.
Provisional list of what?
Provisional list of seniority of senior assistants.
Where is that?
My lord, that provisional list, your lordship will kindly find at page number 48. My lord, that is not the provisional list, that is of their my lord, the gradation list of that is
All right, you find out.
my lord, page number 54.
You have to give us materials against that.
22. And here, if my lord takes up page 54, your lordship sees, in fact, in regard to this list, objections were invited to be submitted within 7 days. The list your lordship will kindly find at page number 55. This is the provision.
Mr. Chakravarti, because things are in a little haphazard manner,
My lord,
I will only decide the writ petition. You can argue on that.
my lord. Now,
Anything which is not there in the writ petition will not come.
in the writ petition itself, my lord.
Achha.
In the writ petition, my lord, page number 54,
Page number 54.
my lord, the provisional list.
You have filed affidavit in the writ petition.
Yes, affidavit in opposition file. My lord, file. This is also something, I don't know why it has been, this is in the record. Affidavit in opposition has been received. I don't know why they have taken up this plea in their response to my IA that I have made a false statement that I have filed the opposition. Well, there is a receipt. And how can an affidavit in opposition get filed without receipt of the petitioner's counsel? That is there on record.
We have not provided in the copy. That is why you have stated, Lordship, we have not getting.
Now you have got it.
Lordship, we have not got it.
No, I'm asking in the writ
Affidavit
petition.
in opposition, we have not got it, Lordship. They have stated that they had filed an affidavit in opposition. We have not received any copy, such copy.
Well, it is received by them and it's on the record, but if my senior friend.
Then we'll
insists-
first decide on whether affidavit is filed or not. It's a pity that.
My lord, this is
High
unfortunate,
Court-
unfortunate, my lord, because. this-
Unfortunate, but you are also party to the
I am,
unfortunate.
my lord, perhaps not a guilty party to this, perhaps, my lord, in my humble contention.
No, but no order will be passed today. He
My
says
lord,
he has
I
not
understand,
received
my lord, but in any case, my lord, the affidavit in opposition copy, if my senior colleague says he has not got, I have copy of affidavit in opposition, which I can hand over instantly. That's not an issue.
Then hand over.
Yes, my lord. This is in respect to 323. And then in the other writ petition also, my lord, I have filed affidavit in opposition. This is in respect of 605. Anyways, my lord, page number 50,
Affidavit in opposition,
in both the writ petition.
there are two writ petitions.
Yes, my lord. Item number 8 is another writ petition. I'm coming to that, my lord. I'm coming.
No, so you're ready for final disposal today?
Lordship, I have to go gun through the Lordship, this affidavit in opposition. And
You have received the counter affidavit. You have received.
Records on a regulation.
Then we'll fix it on 11th for further hearing as parted matter.
Obliged.
Heard Mr. S.K. Goswami, learned counsel appearing for the writ petitioner in both these petitions. Also heard Mr. D. Chakravarti, learned counsel appearing for the private respondent number 5. Ms. J. Gogoi, learned counsel is present on behalf of the Water Resources Department. These matters have been heard in part on the request of learned counsel for both the sides. Let these matters be listed again for further hearing on 16th May, as fixed parted matters.
obliged.
Obliged.
My lord, in this matter, on the last occasion, I had argued that because rule 173(8) of the BSF rule had not been followed, the dismissal would not be legal in law. But I had given also a judgment of this honorable court, and lordship had directed the respondents to find out if the judgment had been appealed from or had it been implemented. If this earlier
Yes,
has been
I've
followed.
got the answer.
নাই কল নকৰো বুলি কৈ দিছে না ব্যৱহাৰতে আছে From 7th line, Lordship.
The order has been implemented.
Yes, Lordship. And next page is also the note sheet, and they had at para 10, 11 and 12 also given the reason of
So can you just give a brief recapitulation of the?
My lord, yes. The petitioner, my lord, he had joined his services, my lord, immediately below the synopsis part, my lord, I have given a list of date in the petition itself.
Hmm.
That perhaps should be, my lord,
Yes.
my lord, immediately below the synopsis, my lord, the list of date is there. I had given event wise. Then, my lord, at the top, 2004, I joined my services. 2009, my lord, I had availed leave from 16 to 26. Then, my lord, 25/7/2009, the Court of Inquiry was ordered, my lord. 5/9/2009, the Court of Inquiry assembled. On the same date, 5/9/2009, witnesses were examined. Thereafter, Lordship would find at 18/9/2009, I was given a show cause notice. Then, my lord, on the next page, 22/3/2010, I am informed that I was dismissed by order dated 12/11/2009. I did not have a copy of the dismissal order. Without that, on 13/9/2010, I preferred an appeal. I was required next to submit all my medical documents. And my lord, the appeal comes to be dismissed on 7/12/2010. Here, my lord, I have, in this petition, I have said that the provisions of 173(8) have not been followed of the BSF rules.
Which provision has not been followed?
173(8) of the BSF rules.
173(8).
173 within bracket 8, my lord. And the judgment that I have cited
Hmm.
is exactly on the same point.
173(8) and
173(8) is the only provision, my lord, because I was not given a hearing during the Court of Inquiry proceedings. May I read 173(8), my lord?
yes.
Well, 173 starts with the procedure for courts of inquiry. Then 173(8) says, before giving an opinion against any person subject to the act, the court will afford that person the opportunity to know that all has been stated against him, cross-examine any witness who have given evidence against him, and make a statement and call witnesses in his defense. This part was not done, my lord. Now, the next, the proviso, provided that in this provision shall not apply which inquiry is ordered to inquire into a case of absence of duty without due authority. This lordship will find was inserted on 25/11/2011. Now, my lord, my Court of Inquiry was held on 5/9/2009. The judgment that I have placed before this honorable court, it records that the Court of Inquiry being held prior to the insertion, therefore, the dismissal order has to go and I have to be given a fresh opportunity to appear before the Court of Inquiry. If I do not appear, then my lord, they may proceed ex parte against me, and my benefits in the interim period will be dependent on the outcome of the Court of Inquiry. There is a para 13 of the judgment. Para 12 and 13. And at para 11, this pre-amendment and post-amendment is given.
So this 173(8)
My lord.
says before giving an opinion against any person
My lord.
subject to the act, the court will afford that person the opportunity to know all that has been stated against him,
Yes.
cross-examined by witnesses who have given evidence against him, and make a statement and call witnesses in his defense.
My lord.
That opportunity was not
Was
given.
not given to you that they have admitted at page 56, running page 56, para 9 of the affidavit in opposition, paragraph 16. Paragraph 16, that with regard to the statement made in paragraph 13 of the petition, the deponent begs to state that as per section 62 of the BSF Act 1968, when a person subject to this act has been absent from duty without due authority for a period of 30 days, a court of inquiry shall be constituted under section 62 of the BSF Act. It is pertinent to state herein that the inquiry is held in absentia, and thus question of applying 173(8) in an inquiry conducted under Rule 62 does not apply to the instant case. So they have stated that they will not apply 173(8). This honorable court has held that if it is prior to the insertion, that 173(8) has to be followed, and I will be given an opportunity. That lordship will find that paragraph 10 of the judgment.
Paragraph
10 of the judgment that I had given, my lord. Prior to that, a discussion on 173(8) and 62 relationship, para 10. A perusal of 173 of the BSF Rule 1969 shows that the proviso to 173(8) has been inserted by SO number so and so dated 12/11/2011. The present case, the court of inquiry had been held on 27/10/2008 and concluded on 1/11/2008 prior to insertion of the proviso to 173(8). Accordingly, the proviso to 173(8) is not applicable to the present case. Then para 12. In view of the above facts, it is clear that it was mandatory on the part of the respondents to have caused a show cause notice to the petitioner, informing him that a court of inquiry was to be held against him, and there he should have been made aware of all the charges that were framed against him so as to enable him to participate. Same having been not done, entire proceedings in the court of inquiry, consequential findings and decisions made to be vitiated. The consequence of the same is that the dismissal order also stands vitiated. Accordingly, in view of the reasons stated above, the order dated 19/10/2019 issued by the respondent dismissing the petitioner from service is hereby set aside, along with any consequential orders. Petitioner should be accordingly reinstated. The court is not passing any directions with regard to any consequential benefits, entitlements, or continuity of service of the petitioner in view of the fact that the apex court in the case of so and so reported in 2009 9 SCC 601 has held that there is a misconception that whenever reinstatement is directed, continuity of service and consequential benefits should follow as a matter of course. The above being said, the respondents are given liberty to initiate a de novo court of inquiry against the petitioner after giving him notice of the proposed inquiry. I would have argued on the basis of Deepakundu Survase that the past benefits should be given to me, but since I'm relying on a judgment of this honorable court, I'll have to rely upon it fully, my lord. I will not refer to Deepakundu Survase on that. Part of this and part of that I'm not doing it. And in fact, my lord, I also found a judgment of the High Court of Jammu and Kashmir exactly on the same point, giving the same relief. The relief being given. If lordship would just like to go through it.
So the inquiry was under 62.
62 says that in case of an absence, the court of inquiry has to be held. How the court of inquiry has to be held is given in 173(8) rule. This was from the Jammu and Kashmir High Court, my lord. Para 10, I have marked 173(8) requires to be followed. Same process, de novo inquiry, everything is necessary. And section 62 says, my lord, 62.
So de novo inquiry, they will be entitled
Yes,
to
yes.
proceed afresh, de novo inquiry.
I will only need an opportunity to show that I could not attend duties. Why I could not attend duties, they will consider not.
First para of the judgment, para 13 also.
Sorry,
The judgment of para 13 is clear, lordship, not there.
There are only one indulgence, if I may seek, my lord. The petitioner has been out of service from around 2012. The petition being filed, my lord. If lordship would only direct them a time frame to give me the notice or allow me to go
so
and
first
report.
he has to be reinstated.
Yes.
Then only you can
The
proceed
court of
afresh.
inquiry has to go on.
Only one thing I want to submit, lordship. Here
Submit, but in the mic. in the
Yes, sir.
microphone. Yes.
Here, Lordship, in his writ petition, he had argued that he had taken that plea that 173(8) was not followed, Lordship. This judgment is of 2018, Lordship. But the present case, then also, Lordship, there is no initiation from their side to list or pass a judgment, Lordship. So 11 years already lapsed, Lordship. This time also, I prayed before your Lordship for listing. It's an old case, Lordship. So
Heard Mr. R. Majumdar, learned counsel appearing for the writ petitioner, also heard Ms. B. Sharma, learned CGC appearing for the respondents. The writ petitioner hearing, who is an ex Border Security Force, bracket BSF constable, has approached this court by filing the present writ petition, assailing the order dated 12/11/2009, passed by the commandant of the 27th Battalion, Border Security Force, dismissing the petitioner from service, inter alia contending that the provisions of Rule 173(8) of the BSF Rules 1969 has not been followed in this case, and therefore the impugned order as well as the inquiry proceeding, which had commenced on 5/9/2009, stands vitiated in the eye of law. Full stop. The facts of the case in a nutshell is that the petitioner had joined as a constable in the BSF in the year 2004, but he had remained absent during the period, during the period from 1/6/2009 to 26/2009, the petitioner had to avail casual leave, 15 days casual leave.
This is Sunday and Saturday is prefixed.
Not going into all this. They joined in the year 2004. While in service, the petitioner had to avail 15 days casual leave with effect from 1/6/2009 to 26/2009. To 26/2009, with 3 days in between. VI is at 7th, 14th, 7th and 14th June being Sundays, and 18th to 20th of June being the joining period. Full stop. The petitioner claims that he was not keeping well on being diagnosed of being infected with hepatitis associated with malaria and was advised bed rest for the period for the same period till 12/12/2009. Full stop. However, the commandant, that is the respondent number 4, was of the view that the petitioner had overstayed his leave and accordingly ordered a one-man court of inquiry so as to inquire into the reason for such overstay. The Court of Inquiry assembled on 5/9/2009 and after examining 5 witnesses and 11 documents, had given an opinion that the petitioner may be declared a deserter and disciplinary action be initiated against him, including issuance of apprehension roll. Is it apprehension?
Apprehension roll.
For recovery of the I-card. Full stop. Consequently, follow-up action was initiated, which had culminated in the order of dismissal from service dated at 12/11/2009. Full stop. The appeal preferred by the, why two orders rejecting the appeal?
My lord. No, they
The
are not,
appeal preferred was rejected by order dated 7/12 and 9/1. Innocent of this.
19-1, my lord, 19-1, I made a representation to the DG.
The appeal preferred
Basically-
by the petitioner against the order of dismissal from service was rejected by order dated 7/12/2010. And what is 19/1/2011?
My lord, that was my, one of my representations to the DG, my lord, that doesn't fall in the category of appeal, my lord. I wrote to the DG says your case is already closed.
Person whereto the petitioner had submitted a representation before the Director General of BSF, namely respond number 2 on 19/1/2011. However, the said representation was not entertained by the respond number 2 on the alleged ground that the matter was already closed. Situated thus, the petitioner had approached this court. Petitioner has approached this court by filing the instant writ petition. Mr. Majumdar has argued that the court of inquiry was conducted behind the back of the petitioner without serving any notice upon him or giving in him.
Lordship, so cause notice was issued, Lordship.
That is after.
No, only the court of inquiry.
Court of inquiry.
After the court of.
Mr. Majumdar submits that the proceedings in the court of inquiry was conducted without serving any proper notice or giving the petitioner an opportunity of being heard in the matter, and hence the same was in clear violation of the provisions of Rule 173(8) of the BSF rules. Full stop. Contending that the case of the petitioner is covered under the decision of this court rendered in the case of Satish Kumar. Bracket force number, you'll get it from here, so and so XSI. Ministerial versus Union of India and others, wherein a similar procedure adopted against another BSF constable in violation of Rule 173(8) of the BSF rules was set aside by the learned single judge, and a direction was issued to reinstate the constable back in service with liberty to initiate de novo court of inquiry against the delinquent. Full stop. Mr. Majumdar submits that since the proviso to Rule 173(8) was inserted with effect from 25th of November 2011, and the same would not have any retrospective application in this case in view of the fact that the court of inquiry was commenced on
5/9/2000.
5/9/2009. That is before the insertion of the proviso. Full stop. Ms. Sharma, Lanet CGC on the other hand submits that
Lordship, phase 3, para 6 of my affidavit, Lordship. Phase 3, para 6, 11th line, Lordship. So after completion of said court of inquiry, apprehension roll was issued to superintendent of police so and so to apprehend individual so and so.
these are not relevant.
Lordship.
Whether notice was issued. under
Thereafter,
seven-
is of course notice was, but here, what is the difference, Lordship? Here, on after getting the so cause notice, he replied. Then that's subsequently the court of inquiry, he was not allowed, that was not mentioned, but here he had never appeared.
Now, there he appeared, there he didn't appear. What does the court understand?
The so
Which is
called
the
notice,
there and which is
Lordship,
the?
so called notice, we gave him 30 days time to
Whom,
submit his
whom?
petitioner, Lordship. We gave him 30 days time to reply to our so called notice. He had not, Lordship.
Ms. B. Sharma, learned CGC, appearing for the respondents, has invited the attention of this court to the statements made in the counter affidavit in paragraph 6 and submits that in the present case, a notice was issued to the petitioner, but despite receipt of same, he did not reply to the notice sent by the authorities. As such, the ratio of the law laid down in the case of Satish Kumar bracket Supra would not be applicable in this case. Full stop. The learned CGC has, however, submitted in response to a query made by this court by order dated 25/4/2023 that the decision of the court rendered in the case of Satish Kumar Supra has been implemented by the authorities, and the concerned BSF constable had been reinstated in service in terms of the order of this court. Full stop. Full stop. After hearing the submission of learned counsel for both the sides, the core issue that would arise for consideration of this court in this case is as to whether there was any duty upon the authorities to give an opportunity of being heard to the petitioner under under Rule 173(8) of the BSF Rules 1969. Full stop. The opposite issue has been decided by the learned single judge in the case of Satish Kumar bracket Supra. The relevant observations made in the said decision are reproduced herein below for ready reference. There are 10 to 13. You have to quote, it is here, 10 to 13. In the present case also, the court of inquiry was evidently held under section 62 of the BSF Act 1968, and the procedure that was required to be followed in the matter was laid down in Rule 173 of the Rules of 1969. Full stop. Rule 73(8) enjoins a duty upon the authorities to give an opportunity to the constable of being heard in the matter. Full stop. However, no such opportunity was given to the petitioner in this case. Full stop. It may be correct that some notice was initially served upon the petitioner, but that was prior to initiation of the court of inquiry, is it?
After everything had happened.
But that was
After the court of inquiry
the
had.
court of inquiry was concluded and the opinion was given by the
Court of
court
inquiry.
of inquiry. Full stop. Serving notice at this stage would not be in compliance with the mandate of rule. Once serving notice at this stage, in the opinion of this court, would not be in compliance of the mandate of Rule 173(8) of the Rules of 1969. Full stop. What is required under the rules is an opportunity of being heard at the stage of the inquiry and not after conclusion of the same. Full stop. In view of the above, this court is of the opinion that the case of the petitioner is squarely covered by the decision rendered in the case of Satish Kumar. Full stop. The impugned order dated, what is the day order? 12/9.
12/11/2009.
2009 is accordingly set aside. The respondents are directed to reinstate the petitioner back in service, whereafter they would be at liberty to proceed de novo against him after serving proper notice as contemplated under Rule 173(8) of the Rules of 1969. Full stop. Since this is an old matter and the petitioner has remained out of service for more than 10 years, hence it is ordered that the procedure it is ordered that necessary steps under this order be taken as expeditiously as possible, but not later than 4 weeks from the date of receipt of a certified copy of this order. With the above observation, read petition stands disposed of. And what is the IA?
No, that is for deletion of name of
Read petition stands disposed of.
Lordship, would Lordship like to add that presently this proviso, it is there in the paragraph 13, Lordship. Lordship would like to again mention it that because after 2011, if he is now in absence, there is no necessity to.
Needless to say that since this court has granted liberty to initiate de novo one-man inquiry, the provisions of the rules as in force as on date would only be applicable in this case.
In that case, they will not give me notice of the court of inquiry.
But they will have to give you a notice.
So now
If
as of,
he will not appear,
No, he
then
will-
if I don't appear, then it's a different matter.
You will be reinstated.
Oh, yes.
Then automatically, in absentia only, there is no
Definitely.
required. You will be reinstated first.
Right.
Then then automatically proviso doesn't come into play.
Right.
Obliged.
Lord, in this matter, I have filed my affidavit today only, my lord. Additional affidavit, and it is not taken in the record actually, my lord.
Well, in this case, Lordship, the main impediment is that both the petitioners have already been retired from the service, my lord. And the out of my lord, the three private respondents, my lord, two have already been retired, my lord. Now, as per my instruction, Lordship, 3 clear vacancies are there in the post of the. So, my lord, keeping in view everything, they may relook the entire issue, my lord. If some national promotion can be given to them, my lord, after giving the hearing of all the sides, my lord. Instead of pending, because they will not cannot be physically put in the, even if it is granted, only if national promotion can be considered for the purpose of financial benefit. That is the, my lord. Otherwise, they have also admitted in their additional affidavit, my lord, the petition, the respondent number, they are recommended by the APSC in the PWD roads, my lord. But since they are continuing in the veterinary department on a temporary basis, they are absorbing the.
So do you want a adjudicatory order or simply a disposal of representation?
Representation we have not filed, my lord. Only the thing is that, my lord, keeping in view the facts and circumstances of the case, my lord.
If you want a adjudicatory order, then we'll have to have it along with the affidavit.
Lordship.
It's not possible today.
Or my lord, I understood, Lordship. Or then, my lord, the pendency may not be a bar to consider. If it is considered, then it's.
If you want to file a representation, then that order we can pass. But if you want an adjudicatory order, anything declaring rights, liberty, then the affidavit has to be looked into.
Yes, my lord. Then Lordship may kindly give a short date because I
Right.
can't file the affidavit in reply.
Heard
Also, my
Mr.
lord.
Vijay Ghosh, Learned Counsel for the petitioner.
It is
Also heard Ms.
M.M. Kotoki.
M.M. Kotoki, Learned Counsel appearing for the Agriculture Department who submits the affidavit filed. on-
Veterinary department, my lord.
Veterinary Department who submits that the affidavit filed on behalf of the department today.
Today, my lord.
That is, give the date, is not tagged with the record of this case. You are
P. Sharma, Lordship, for respondent number 3.
Ms. P. Sharma, Learned Counsel has appeared for respond number,
3,
respond number 3. You want to file affidavit?
Lordship. The department's affidavit has covered.
Who submit that the affidavit filed by the department would cover the stand of our client. First of, since the affidavit would play a vital role in the outcome of this case, but the same is not tagged with the record, register to list this matter again after 2 weeks by tagging the affidavit with the record of this case. The petitioner may file rejoinder in the meantime if so advised.
Well, date may fix.
Date will be in June.
My lord,
Fixed date will be in June. Either after 2 weeks or June, you choose.
after two, better, my lord, another, okay, my lord.
What do you want?
After 2 weeks, it will never come, I know, my lord. Maybe fixed at the month of June, my lord, date may be fixed.
Let this matter be listed again on 6th of June.
Lordship.
Obliged.
Lordship, I pray that it may be passed over for the time being, Lordship.
Time being not possible today. What is this matter about?
My lord, here we have challenged the penalty order, my lord, by which impose the penalty of reduction in the time scale and my lord, the recovery of rupees 1,91,000 from me, my lord. After this year.
Ready for hearing? My lord. Yes, start arguing.
Here, my lord, I will place the facts, my lord, as per the annex otherwise, my lord. That lordship will find the page, my lord, 27, my lord. The petitioner is, my lord, the record clerk in the, my lord, LIC, my lord. And while serving, my lord, this FIR dated, my lord, 12th of October 2012 has been filed by the Chief Minister of United Bank of India, my lord. Married, my lord, that FIR, my lord. On 26/9/2012, my lord, at Bank's Fancy Bazaar branch situated at Laktokia, Guwahati, an amount of rupees 1,91,000 has been withdrawn in fraudulent manner. This said that around 2:45 PM, one check number 401,654 for rupees 1,91,000 was presented for such payment from LIC account number so and so. And as per normal course of procedure, after verifying signature and other aspects, this said check was paid by bank. On 4/10/2012, we received a letter from LIC that said check was fraudulently encased. The bearer who had come to the bank for encashment of this said check was regular messenger of LIC. It is strongly apprehended that the bank has been duped of rupees 1,91,000 by an outsider. Under the above circumstances, we would request you to take steps for a thorough probe so that the culprit may be booked and money may be recovered. Further information, if required, may be furnished to you. That affair has been registered as Panbazar PS case number 344 of 12 under section 420. After investigation, my lord, the police has submitted, investigating officer has submitted charge sheet that lordship will find page 29. Page 29, my lord, is the charge sheet, my lord. Here the charge sheeted accused, my lord, is one Purnima Das, my lord. And the lordship will find in page 30, my lord. Right hand side, my lord.
No, Purnima Das is not sent up for trial.
No, sent for trial, my lord.
Please read page 29, name and address of accused person, not sent up for trial.
My lord.
Here the name is Purnima Das.
No, actually, my lord, in the page 31, my lord, that is the type copy, my lord. Translated type copy, my lord. That's why, my lord, just mistake has cropped up. In page 31, my lord, actually, my lord, in column number 3 and 4.
No mistake, same thing is there, not sent up for trial.
No, my lord. But my lord, it is, my lord, indeed, lordship will find it page 30, my lord.
Okay, would you like to look into this matter? It will have a bearing in your case.
My lord, it does affect, my lord, because the name has been, my lord,
So what you are arguing, the materials are contrary to that.
yes, my lord.
I'll go by the material.
But my lord, indeed, my lord, page 30, my lord. If lordship will find up during investigation, the statements of the witness have been recorded.
Mr. Sharma, I'm asking you one thing.
Yeah, this is correct, my lord, but that, my lord, I think, my lord, this is in the middle portion, page 31, my lord, they have written.
So you want to proceed in this format without verification, then you proceed. But what will matter is what I have seen, not what you say. What is on record will only, that is what will matter.
ভেরিফিকেশন করতে পারি 32 তো কলম হয় তো ভেরিফিকেশন আমি কৰিব পাৰিবা কৰিব পাৰিবা কৰিব
Choice is yours. You can argue if you want. But if I
Well-
hear, I'll finish it. I'll conclude it today.
But my lord, I am pointing out that the base 30, it is findings of the investigations officer, my lord. That is, but his lordship find it is correct that it is in the middle portion, page 31, it has written. But whether, and if required, my lord, I will,
No, it is for you. I'm not suggesting anything. All I'm saying is,
I can
if we
get a
go into the
certified.
hearing, I'm not keeping the matter as part heard. I'll finish it off.
Yes,
today.
right.
Then you will not get a chance to revert on that.
Like my certificate.
Because this part heard thing is creating problem. Little bit of hearing and then keeping it part heard is creating problem.
Then my lord, lordship may adjourn
Up
this.
to you, up to you. If you
And
want
my
to
lord,
argue, no
I
problem.
will take up a certified copy of
Only
this.
thing I am saying is, at the conclusion of hearing, don't say that, give me 2 weeks time to
No,
clarify.
no,
That I will not.
No, my lord. Because I will take a certified copy of this proceedings, my lord, then I will,
Because these are very crucial
Yes, yes.
factors. You
I am not
submit
certified.
something orally and in the document, something completely different is there.
my lord, the evidence, my lord, I will come to later part, my lord. My lord cannot conclusively drawn the, my lord, the search, cannot conclusively prove the search against me.
But
And-
what is the point here?
Point here is, my lord, the evidence during the, my lord, departmental proceedings, my lord,
Hmm.
is, my lord, cannot conclusively, my lord, prove the search against me, my lord. And the, my lord, what happened, my lord, the inquiry officer, my lord, held that the, in his report, held that the search does not prove. It is, though it is says that the merely partially prove, but there is no any finding and it is not proved.
Hmm.
And my lord, the disciplinary authority, my lord, deferring the, my lord, the report of the inquiry officers impose the punishment, my lord. And that, my lord, the
But before deferring, was any notice served upon you?
notice served, my lord, that hearing was not provided, my lord. That's the, my lord, I have raised one issue, my lord. Hearing is
Any
required.
judgment covering
Yes,
that?
yes,
Hearing also should be given.
yes, my lord.
Which is the judgment? Let us see.
Rumor copy to you. There are 17, my lord.
There are 17.
My lord. If lordship permits me, may I read, my lord? Para 17, page 96.
Yes, he would, was a hearing been given to him while deferring?
My lord, the show cause was issued.
Where is the show cause?
Show cause is here, my lord, at page. Show cause, lordship will find at page, my lord, 70.
Page 70.
Yes, my lord, 70, my lord. 70 and 71 starts the show cause. Because on the basis of the evidence taken into account by in the inquiry, Shokos was issued to him. And according to Shokos, he submitted the representation.
In page 71, last paragraph, my lord, in the middle portion, but I differ with the findings of the inquiry officer on the basis of evidence taken on record and facts and circumstances of the case.
And the inquiry officer found that charges were not proved.
Partially proved. Findings of the inquiry officer, my lord, inquiry report at page 57.
Page 57.
My lord.
So then you have to give him a hearing, Mr.
Hello.
What is the way out? You have to give him a hearing.
My lord,
And the whole thing will go back to that stage. You will have to reinstate him. Give him a hearing.
He is in service.
He is
My
in
lord,
service.
in this, my lord, the case in the Kunja Bihari Misra, 1997 Supreme Court, my lord, I have not brought this judgment now. Supreme Court has said that it is the procedural thing is that if any evidence relied on by the inquiry officer has not taken the evidence properly, then my lord, it is the disciplinary authority can point on the basis of that evidence, can differ. So here, my lord,
Who is saying they can't differ?
Shokos issued was issued on the basis of that.
No, you are on a different point.
My lord.
Nobody is asking, nobody is saying they can't differ. Before differing, you have to hear him. That is the point.
Lordship is saying that the evidence which was not considered properly.
Nothing, we don't know anything.
And that evidence should be, he should get an opportunity to defend before the inquiry.
Before the authority, disciplinary authority differs, he should also not only be able to submit his reply, but also being personally heard.
By the inquiry officer. or
Yes, no, by the
DP,
disciplinary.
By the disciplinary
Yes.
authority.
Inquiry officer is over. That was not done in this case.
My lord.
What is the penalty here?
Penalty?
Penalty lordship will find the page 76.
My lord, is the reduction to the minimum time scale
Yes.
applicable. In the matter of
79 is the, my lord.
recovery of rupees 1,91,000. 91,000 respectively, which in
This is step by step.
And the inquiry report, which page?
Inquiry report lordship will find page 57. 57. And findings of the matter is,
How many charges were there?
my lord, only one charge is there, my lord.
Only one charge.
My lord.
And where is the finding?
Findings that lordship will find. Inquiry report page 57. Page 69.
And where is the decision holding that the charge has been fully proved, fully established?
My lord, that is in the impugned order itself, my lord. They are differing and my lord, they are, there is the manual punishment has been, penalty has been imposed, my lord.
So he has to be, he is continuing in service.
Continuing
You
service.
hear him again and pass a
My-
fresh
that-
order. That's
that-
it. Heard Mr. Harsh Sharma, learned counsel appearing for the writ petitioner. Also heard Mr.
Yes, ma'am.
S. Nath, learned counsel appearing for the respondents. Respond numbers 225. None is, Mr. S. S. Roy, none of CGC is present on behalf of the respond number 1. Full stop. The writ petitioner hearing is an employee of the LICI and is posted as
Record clerk, my lord.
record clerk in the, which office?
My lord, the finance and accounts.
Finance and Accounts, Bombay.
No, my lord. Panbazar.
Record clerk in the finance and accounts department of the office of LIC situated at Panbajar, Guwahati. Aggrieved by the order dated 5/7/2016 issued by the manager bracket PNIR, that is the respondent number 6, imposing the penalty of recovery of an amount of rupees 1,91,000 from the petitioner. Where is the reduction of rank? There is no such order here.
My lord, reduction to the minimum time scale of pay, not rank. To his cadre.
Which page? Reduction to minimum time scale.
My lord, page 79. Last.
Penalty of reduction to minimum of the time scale of pay as applicable to his cadre, and also for recovery of rupees 1,91,000. The instant writ petition has been filed. First up. The facts of the case in a nutshell are that while serving as a record clerk in the
No, that is my lord, wrongly my lord type, my lord, this is finance and accounts.
Finance and Accounts Department in the divisional office of the LIC at Guwahati, a disciplinary proceeding was initiated against the petitioner on the basis of charge sheet dated 15/12/2014, leveling a single charge of
Page 34,
page 34.
my lord. Middle paragraph.
Of failure to maintain absolute integrity and devotion to duty. Full stop. An inquiry officer was appointed to go into the charge, whereafter report dated 18/4/2015 was submitted by the inquiry officer by holding that the charge level against the delinquent officer is partially established. First up, not being satisfied with such finding of the inquiry officer, the respondent number 6 had issued show cause notice dated respond number 6, no, senior divisional manager. Will be respond number
Senior divisional manager.
respond number 4 had issued show cause notice dated
14/6/16.
14/6/2016. Dated 13/6/2016 upon the petitioner informing that he intends to differ with the finding of the inquiry officer on the basis of evidence taken on record and the facts and circumstances of the case. The petitioner submitted his show cause reply on 23/6/2016. First up. Thereafter, the respondents had issued the impugn order imposing penalty, impugn order dated
5th July 16.
5/7/2016, imposing the penalty upon the petitioner as noted above. Full stop. Mr. Sharma, learned counsel for the petitioner, submits that after submitting his show cause reply, the petitioner was hoping to get an opportunity of being personally heard in the matter. Full stop. However, no such hearing was given to the petitioner. Instead, the authorities straightaway went to impose the penalty upon the petitioner by differing with the findings of the inquiry officer, taking a different view of the matter without even hearing the version of the petitioner. First up, by contending that the authorities were bound to give an opportunity of hearing to the petitioner, failing which the impugned order of penalty dated 5/7/2016 would stand vitiated. Mr. Sharma has relied upon the decision of the Supreme Court rendered in the case of Punjab National Bank and others versus Kunj Bihari Mishra, reported in 1998, bracket close 7 SSC 84. First up, Mr. Nath, when a counsel for the respondents, on the other hand, submits that law permits the disciplinary authority take a different view in the matter based on the evidence available on record, and thereby differ to disagree with the finding of the inquiry officer system. Therefore, the records adopted by the respondent number 4 and 6 cannot be found fault with due to procedural irregularity system. Mr. Nath has, however, submitted in his usual fairness that no personal hearing was given to the petitioner before issuing the impugned order dated 5/7/2016. The issue as to whether a personal hearing to the delinquent officer is mandatory if the disciplinary authority wants to differ with the finding of the inquiry officer came up for consideration of the Supreme Court in the case of Kunj Bihari Mishra, bracket Supra, wherein the following observations had been made in paragraph 17, I quoted paragraph 17, first of. From the law laid down, next paragraph, in the case of Kunj Bihari Mishra, it is apparent that it was mandatory upon the disciplinary authority to give a hearing to the lead petitioner before differing with the finding of the inquiry officer. First up, by not giving such a hearing, the authorities have acted in a manner which led to violation of procedural safeguards, and thus they acted in contravention of the principles of natural justice. First up, if that be so, the impugned order dated 5/7/2016 cannot be sustained in eye of law. However, since the impugned order has been interfered only on procedural grounds, it will be open for the authorities to pass a fresh order after hearing the petitioner. After giving a personal hearing to the petitioner. First up, this writ petition is therefore disposed of by setting aside the impugned order dated 5/7/2016. First up, 5/7/2016 by clarifying that it will be open for the respondents numbers 2 to 6 to proceed against the petitioner from the stage of receipt of show cause notice, the show cause reply dated. What is the date of the show cause reply?
My lord, show cause reply, my lord, 23/6/2016 in the second show cause.
23/6/2017. 2016. And after giving a personal hearing to the petitioner, the disciplinary authority may pass fresh orders on the question of penalty to be imposed to the petitioner. Writ petition stands allowed to the above extent. There will be no order as to cost.
My lord, one thing, my lord, the recovery part, my lord, that has already, my lord, as per my instruction, my lord, that has already been, my lord, continued, my lord. So that recovery may be, my lord, returned back, my lord.
Until such time the above exercise is completed, no further coercive action shall be taken against the petitioner. It has been done, you want it to be refunded. That cannot be done. No further coercive action.
Yes. Right.
No, please, your lordship. Well, the petitioner before your lordship is a police constable, my lord, who was dismissed from service, my lord. What happened, my lord, on 4/10/2019, an affair was lost by 3 persons, alleging that while they were traveling from Jurabad to Shillong in a taxi with 60 numbers of gold
You
biscuits.
got the records. How long will it take?
I only sole ground, my lord, without examining the witnesses on the basis of whose complaint the DP was initiated, my lord, they were not examined.
Is there any decision in your favor?
Yes,
We'll see second half. And what is the next item? Who's there in item 17? What is this matter?
This is termination, lordship.
Yes.
may I please, lordship. My lord, the petitioner before your lordship is a constable, my lord, who has been dismissed from service. What happened, my lord, on an affair was lost by 3 persons. And that was registered by the district police, my lord. And on the basis, and subsequently thereafter, my lord, DP was initiated against 2 persons. One SI and the petitioner against the petitioner. And my main grievance is that, my lord,
Who are the 2 witnesses?
3 witnesses, my lord, the complainant.
Complainant is one. What is his?
There are three complainants.
Give the numbers of the witnesses.
Number.
PW, something is there.
Yes, my lord.
What is it?
PW, I'm giving 1, 2, and 3 million.
Complainant is PW?
1 million. 1, 2, 3, all are complaining.
All are complaining.
Complaining.
PW2 and PW3.
1, 2, and 3.
What is the complaint?
My lord, your lordship will get it, page 15A.
Page?
15A, Annexure 1. Yes.
No.
Thereafter, my lord, the DP has been completed, but they were not examined, my lord.
Who is not examined?
The complainant. On the basis of complaint, my lord, DP was.
Complainant were not examined.
No, my lord.
As witnesses.
No, not examined.
Then?
And now my another grievance is that, my lord, DP was initiated against 2 persons on the basis of this complaint. He is still in the job, my lord. His DP has been completed, my lord. His DP has been completed and only 1 increment as a penalty, 1 increment has been taken away. So it is a selective punishment, my lord.
Yes, argue your case.
Yes, my lord.
My main argument, sole argument is that, my lord, non-examination of witnesses, my lord.
We don't know. Show us from the record.
From the record, your lordship, I can see. The inquiry report, my lord. At page 25. The findings, my lord. Only one page I have been provided, my lord, of the inquiry report.
So where is the charge? Where is the charge?
Charge is at page, my lord. 21. my lord.
Page
Statement of
number
election.
1.
21.
What happened to the criminal case?
It's still pending. Investigation is going. Investigation is going.
So this is the charge framed against the petitioner. And where is the charge against the other person?
The charge against the other, Your Lordship,
Nipu Kalita, where is?
his charge, I have not annexed millet here, but the final order I have annexed.
Why you have not annexed the charge?
Charge I have not annexed, but it can be reflected. Your Lordship, kindly see the suspension order. It page 18 annexed 2.
Tell me the date when you wanted to post it. I want the charge order, you are telling the
Nipu Kalita.
suspension order.
Yes,
These
sir.
things will not work out here.
Whether it is same. or not.
Yes, your only ground is both of them having subjected to the same charge, same inquiry. One has been released. You can't make out that case unless the charge is brought on record.
And non-examination of witness,
Yes.
my lord, that is the main term. In my affidavit in.
If the allegation is same against both of them, and one of them have been exonerated or given a minor penalty,
Minor
how can you give a major penalty to other? He has not argued this, he is not prepared. That's why the matter is not disposed of. Otherwise, I would have finished up this case today. itself.
My lord, accept the charge, my lord, the inquiry report of Nipu Kalita is there.
I want the charge.
All right.
When can you bring it on record?
Yes, my lord, within a week. my lord.
Mr. I, Rafiq Naik, counsel for the petitioner, prays for and is granted 10 days time to bring the charge framed against the co-accused SI Nipu Kalita, based on which disciplinary proceeding was initiated against him so as to justify the argument that while the petitioner and SI Nipu Kalita were subjected to disciplinary proceeding on the same set of charge based on same set of witnesses, stroke evidence, while the petitioner has been dismissed from service, SI Nipu Kalita has been let off with a minor penalty, thereby extending discriminatory treatment to both the employees, both the police personnel. First up, Mr. S.S. Royal and a government advocate Assam is present and submits that he has received the records. First up, register release this case again after 2 weeks.
Right.
That is your case, you come up with judgments.
Yes.
Merely, you see, if their evidence is not found to be crucial, then that itself will not be enough.
My lord, there are our division bench judgment as well as the Supreme Court judgment.
So you don't want to go
No,
into
no,
that.
no, no, no,
Then you tell me, I'll hear you today itself.
no, no, I will bring that in
All right.
record. All right.
What
May I
is
please? In this case, I am not going to take up the case, just going to the relevant point of law, Lordship. Yes, because Lordship, the advertisement was issued on 24/1/2015, Lordship, whereby call for the post of constable in Assam Rifle, Lordship. So advertisement is a relevant document, so Lordship, if same has not affixed with the record, and if it is Lordship. On basis of the advertisement, Lordship, I was appointed as a constable, Lordship. That is the appointment letter, Lordship, Annexure A, page number 23, Lordship. I was appointed, page number 23, Lordship. After duly qualified of the Viva as well as the physical test and medical report, Lordship, I was provisionally being appointed, Lordship. Page number 23, Lordship. Column number A, Lordship, can be perused, Lordship. The post is combatized and purely temporary, but likely to continue on appointment on the said post. You will be a probation for a period of 2 years on successful
Just
completion.
a minute, what is this case? I couldn't make out any head or tail from the synopsis.
Lordship, actually, he had fabricated document at the time of appointment. He had not passed HSHS, which is the necessary requirement, and he himself in his representation I annexed. Finally, Lordship, after so many procedures, Lordship, he submitted that, yes, he had fabricated HSS certificate of another person in his name, as because at the time of appointment, he had not passed. Subsequently, he had passed it from Assam State Board, but at the time of appointment, Lordship, he had not passed, Lordship. So he was the temporary employee, so his service is terminated under CCS temporary services rules. And because his service was not permanent, although he had completed 2 years, but the rules say that unless it is confirmed by the order, he still remains a temporary employee. And so by giving 1 month notice, he was terminated on the ground of fabricating false document at the time of appointment.
His lordship, that is the termination order,
Where
lordship.
is the order?
That
Let
is
us see.
30 April 2021.
Page
lordship.
number.
Page number 32, lordship. Annexer D, lordship. On basis of this order, lordship, I have challenged.
What is the ground of
Again,
challenge?
this order, lordship, I have filed an appeal petition before the higher authority, lordship, but appeal was not disposed. Accordingly, I filed another writ petition whereby this court, your lordship, has directed to the respondent authority to dispose of the appeal within a period of 45 days by giving an opportunity being heard, lordship. This is the order, your lordship, but I was not given any opportunity. So, lordship, I am not going to fact of the case, it may be or may not be. But, lordship, being it is because, lordship, temporary government employee should have been removed by as per procedure of law,
No,
lordship.
you have fabricated the document. You admit that.
Lordship, I will prove my innocence before the disciplinary authority, lordship. If disciplinary authority will be conducted, I will produce my innocence,
Have
lordship.
you fabricated the document or not?
Lordship, I don't know, lordship, but lordship, I was qualified, lordship. So, lordship, one opportunity may be given, lordship. I will establish my innocence before the
You have
authority,
to
lordship.
first answer the whether did you fabricate the document to get employment? Yes or
Lordship,
no?
no disciplinary proceeding has been conducted as because your
Let
lordship
this
has
matter be
also,
listed
your
before
lordship, kindly your lordship order dated lordship 21/1/2022, whereby directed to the respondent authority, lordship, to dispose of the appeal petition within a period of 45 days from the
You
date of
will
receipt.
have to answer the question of this court, Mr. Saikia.
Yes,
You better do it straight away.
yes.
Has your client fabricated documents to get employment? Yes or no? Without that answer, you are not going anywhere.
That is, lordship, that is a
Yes or no? Tell
contradictory.
me that.
Contradictory. I am not at the point you answer, your lordship or answer. But lordship, I have qualified in any other board, lordship. Not because the SEBA, lordship, but the Sanskrit board I have qualified. Now, lordship, on basis of the law point, I am stand before your lordship. Being a temporary government employee, I have a certain right, lordship, prescribed by the APES code, as well as the procedure of law. Even lordship, in the termination order, nowhere mentioned that, lordship, only stating that this unit is overstaying from leave effect 13/2/2021 and personal service of this notice is not practicable. Therefore, under the provision of note so and so, CCS rule so and so, you are terminated from the services. During that time, lordship, lockdown was pronounced by the state government and the central government, lordship. Even my mother was suffering illness. That time I could not resume my services. Therefore, I also filed reply notice to my authority, lordship, at least given sufficient opportunity to me, lordship, to produce my documents as well as to establish my innocence before the authority. That is what is the fault of me, lordship. If your lordship has reinstated me, definitely liberty upon the disciplinary authority, the higher authority, to conduct any disciplinary proceeding against me, lordship, they can further stage remove me from my services. Liberty upon them, lordship. Now, my prayer is that just at least being a citizen, lordship, I may be given a reasonable opportunity to being heard, lordship, and establish my innocence before the authority. So, lordship, provisional period has already been expired. I rendered my services more than 4 years, lordship, in Jammu and Kashmir, Srinagar, lordship.
So, Mr. Saikia, the law is totally against you. It may be either you are not aware or despite being aware, you are pretending not to be aware. The second one is not a good idea, but law is against you.
I cannot praise that the innocence.
In probation, unless it is confirmed, you remain in
Yeah,
probation.
well, I only approached before lordship on law point, I may be given opportunity on fact of the case.
So what
I-
you convinced the court, what is that you want to say?
No,
It is-
I am unable to,
Hmm?
I am unable to submit before lordship that I am genuine.
What to do? You see, we have to
But
do just.
I approach only before your lordship. To give me one opportunity, lordship, disciplinary proceeding has enough right to
No,
draw the
one
disciplinary
opportunity, if
proceeding,
you are a-
lordship.
If
And
you
they
see,
can
probation
impose
period, no,
punishment.
no question on. Dipto Prakash Banerjee, where is the judgment?
Also, this is our high court on same tax where 15 years, after 15 years, on same reason lordship.
Yes, Lord, it is absolutely right. If someone has falsely and
and-
fabricated the document, he may be terminated.
So
at
you-
any
you
point
have
in event
fabricated
of
the
the crime.
document.
Lordship, only because the opportunity I may be given being half lordship. to establish-
Opportunity, the court must
lordship.
feel, no, that you have,
If two authority have communicated lordship, I am the person concerned, I may be given opportunity lordship.
we are giving you opportunity, say what you want to say.
No, your lordship has order also directed to the authority to giving him proper opportunity. What opportunity I may be given? Lordship, just kindly be patient, lordship, that is the
It is not
appeal
called
order.
termination, it is called discharge.
Yes.
Maybe the authorities also didn't know what.
But lordship, just I may be allowed to one submission, then lordship will pass the appropriate order. Lordship. Lordship, that is, please come, page number 46, Lordship. Page number 46, second, last paragraph, Lordship. Therefore, in the capacity of reviewing authority submitted by the appellant, the statement evidence available in the appeal date to answer, date nil, departmental inquiry file and remarks sent by the commandant 54 battalions, force disciplinary authority and the deputy inspector general, New Delhi appellate authority, and after a thorough study of the documents, I found that departmental inquiry proceeding have been done as per prescribed procedure. What departmental procedure has been done as per prescribed procedure? What opportunity I was given, Lordship?
No
that is the
opportunity is required.
falsely
No
they
opportunity.
mentioned in the this order, Lordship. Page number 46, Lordship. Page number 46, last bottom of this page. That is
This
the
is a
translated-
termination simplicity, there is no stigma also. I was hoping that if there is a stigma, then you can argue, you cannot argue, there is nothing in this. Anyway, you complete your argument, then I'll pass the judgment, nothing can be
Your
done. in
Lordship
this.
will pass the appropriate order.
No, nothing can be done in this case, there is no stigma.
My 101 page number is the 101.
Mr. Saikia, you will be only agonizing, extending the agony of your clients. You will only be extending the agony of your client. Let him be relieved. He cannot be brought back in service.
Yes,
Question
Lordship.
doesn't arise. That is. Yes, pay para,
101, Lordship.
para,
Page 101, my continuation page 101.
yes.
That is, finally, we have admitted that he had forged the document. After twice, we have re-verification.
Page 100,
Lordship.
page 100.
100 and 101 and 102. 100 is the vernacular and 101 is the type copy. How the family public is it not?
Take down, heard Mr. M. Saikia, counsel for the, I'm
Yes, sir.
dismissing your petition.
Lordship.
If you
Yes.
want adjournment, you. take it.
Lordship will done as per
Yes.
law.
Mr. M. Saikia, counsel for the petitioner, also heard Ms. B. Sharma and CGC appearing for the respondents. The petitioner has approached this court assailing the order of termination of service dated 30/4/2021 issued by the Commandant -54 BN CRPF, that is the response number 5, full stop. The petitioner herein was earlier provisionally appointed in the post of constable under the Central Reserve Police Force CRPF on the basis of offer of appointment made on 26/4/2017. Full stop. As per the terms of appointment, the petitioner was to remain on probation for a period of 2 years. Whereafter, you would be considered for confirmation. The offer of appointment dated 26/4/2017 had also clearly mentioned that the service of the petitioner would be liable to be terminated without assigning any notice and without assigning any reason upon giving 1 month's notice during the initial period of 2 years in accordance with the Central Services Temporary Services Rules 1965. Here in short, rules of 1965, the bracket or I go. Full stop. During the continuation of the probation period of the petitioner, the authorities found that he had overstayed his leave. Full stop. That apart, it was also detected that the petitioner had submitted a fake matriculation certificate in support of his candidature, based on which the offer of appointment dated 26/4/2017 was issued. Full stop. Upon detection of the aforesaid fact, the impugned order dated 30/4/2021 was issued by invoking the provisions of Rule 5 bracket numerical 1 bracket close of the rules of 1965. First up, assailing the order dated 30/4/2021, the petitioner is approached before this court, internally contending that he was not given an opportunity of being heard before the impugned order was issued. Full stop. Ms. P. Sharma, Lanet CGC, on the other hand, has invited the attention of this court to the documents annexed to the counter affidavit filed on behalf of the official respondents to submit that the petitioner has admitted that he had used fake certificate to show that he had passed matriculation examination, based on which the offer of appointment was issued to the petitioner. First up, since the petitioner has admitted his involvement in forgery, instead of initiating a departmental inquiry, the petitioner was discharged from service since he was under probation period. First up, it is also the submission of Ms. Sharma that as per Rule 5 bracket 1 of the rules of 1965, as read with the terms and conditions of service, 1 month's notice was duly served upon the petitioner under the circumstances. There is no scope for interference with the impugned order of termination of service dated 30/4/2021 by this court. Full stop. I have considered, then you write, in support of her above argument, Ms. Sharma has placed reliance on a recent decision of this court rendered in the case of XCT/GD 0417111898 Hanif Ali versus Union of India and others, triple bracket WPC number 1055 oblique 2020 to argue that since there is no stigma attached to the impugned order of termination, there was no requirement for hearing the petitioner before issuing the order of discharge. Full stop. I have considered the submissions made at the bar and have also gone through the materials available on record. Full stop. It is the admitted position of fact that the petitioner got his offer of appointment dated 26/4/2017 by relying upon a fake matriculation certificate. First up, the aforesaid certificate was admittedly manipulated by the petitioner by superimposing his name on the certificate of another candidate. First up. Subsequently, the petitioner had passed matriculation, but he has stated that since he was keen to join the force, hence he had resorted to aforesaid forgery of documents so as to avail the opportunity. First up. It is also the admitted position of fact that the initial appointment of the petitioner was on probation for a period of 2 years, but the petitioner's services were never confirmed after the completion of 2 years probation period. Full stop. If that be so, it was evident that the petitioner continued to remain on probation even beyond the period of 2 years. Full stop. Since he had admitted of having used fake matriculation certificate, the authorities, instead of holding a regular inquiry against the petitioner, have decided to discharge him with 1 month's notice by issuing the impugned order dated 30/4/2021. Full stop. The impugned order on the face of it does not cast any stigma on the petitioner, but is an order of termination simpliciter issued in exercise of powers under Rule 5 numerical 1 of the rules of 1965. First up. Since there is no dispute about the fact that the petitioner had used fake certificate while getting the offer of appointment, and considering the fact that he was on probation at the time of issuance of the order of discharge stroke termination of service, I am of the view that remanding the matter back for a fresh decision by the authorities after hearing the petitioner would be a useless formality in the facts of the present case. First of all, moreover, law is well settled that in case of a probationer, the authorities would be entitled to issue an order of discharge instead of holding a regular inquiry for proving the guilt of the employee. First up, such a recourse is permissible when the order of termination does not cast a stigma upon the employee. First up, for the reasons stated here and above, I am of the opinion that there is no merit in this writ petition. The same is accordingly dismissed. Sometimes there are bad cases, you can't help it, not right. Yes, next matter, please. Part 2, anybody wants to do any hearing, final hearing?